do have skills that make me a nightmare for people like you.
Today, 4 witnesses scheduled to give evidence. First, Ms. Sonia Cooper and Ms. Amanda Hill, then Professor Elizabeth Stanley and Mr. Feti Taito. But I'll sit down at this point and let the other counsel introduce themselves.
Thank you.
Tēnā koutou katoa, ko Wendy Alderdaho, Morena and that please the Royal Commission, Council's name is Wendy
Ms. Alderdaho.
Mōrena tātou I hui mai nei ki raro I te maru o tēnei o ngā kaupapa whakahirahira. Kei te mihi atau ki a koutou I whakatūwhera tō tātou rei hui I rongi te runga rawa he manaaki te au tātou katoa. Mōrena I te tepu. This week I'm accompanied by Ms. Davis. I have a difficulty. One of counsel from Rotorua, Mr. Harry Edward, passed away, and he's left his practice basically standing, so a lot of senior counsel are going back to have that work reallocated. So I would seek leave, without disrespect to this proceeding, to be absent for Tuesday and Wednesday to assist my friend who's passed away. Ms. Davis will be joined later tomorrow afternoon by Ms. Bartlett, who was here last week, and they will be here in good stead, I'm sure, with the support of my other friends for this week. This is the first appearance of Ms. Davis before this tribunal. She hails from Ngāti Manu, and I'm sure she's going to be a great asset to our team. Kia ora.
Thank you. Thank you, Ms. Sykes. Ms. Davis.
Yes, may it please the Commission, Ms. McCartney, with my learned co-counsel Ms. Lawton, Tēnā koe Commissioners, and may I, Chair, greet the survivors and other people who are here at the Commission today, this being the first opportunity that I've had to speak. We are here for the National Collective of Independent Women's Refuges in New Zealand. There are 40 in total and more than 1,000 members. We are here to address a number of the terms of reference, including the impact on wider groups in the community of the abuse that has occurred directly to those who are survivors, and to assist in relation to policies and recommendations.
Thank you, Ms. McCartney. Ms. Mount. Ms. Lawton.
Tēnā koutou katoa. May it please the Commission, Council's name is Ms. Dobbs and I appear for the Salvation Army.
Thank you, Ms. Dodds.
Kia ora koutou. Council's name is Ms. McKechnie and I appear with one of the graduates in my team, Mr. Cunningham. We appear for the bishops and congregational leaders of the Catholic Church in New Zealand, Aotearoa. Kia ora.
Thank you.
Tēnā koutou, my name is Mrs. Fiona Guy-Kidd and I appear with Miss Ellie Harrison for the General Synod of the Anglican Church of Aotearoa, New Zealand and Polynesia.
Thank you, Ms. Guy-Kidd. Ms. Harrison. That seems to be everyone. Thank you. Mr. Mount.
Thank you, Mr. Chair. Our first 2 witnesses appearing together, Ms. Sonia Cooper and Amanda Hill.
Ms. Cooper and Ms. Hill, just make yourselves comfortable. There's the initial statement to be made in terms of the Inquiries Act, with which you will be familiar. Can I ask each of you, do you solemnly, sincerely and truly declare and affirm that the evidence you will give before this Commission will be the truth, the whole truth and nothing but the truth?
I do.
I do.
Thank you. Mr. Mount.
Good morning to complete our formalities, in front of you in the folder, we should have a copy of your written brief of evidence. On page 49 of that brief, I think you've both signed. Can I ask you first to confirm that, apart from any corrections that you make as we go through the brief, it is true and correct to the best of your knowledge and belief? Firstly, Ms Cooper.
It is.
And Ms Hill.
It is.
The way we're going to do this is to invite you each to develop certain sections of the brief, and where necessary you'll expand on them, and I may have some questions for you as we go. We spoke earlier about the need to keep an eye on our sign interpreters and our transcriber. The other formality is that we will at certain points be seeing photographs on the screen. We'll have a hard copy of those photographs to produce as a formal exhibit. I'm not sure if that hard copy is ready yet. Most likely we'll do that after the break. Well, Ms Cooper, I think you'll get us underway with paragraph 1.
Ata Marie e te tia mana, tēnā koutou e ngā komihana, tēnā tātou katoa, ko Sonia Cooper aho.
Ko Amanda Hill aho.
We just wanted to start by thank you to the Commission for giving us the opportunity to be heard today. Cooper Legal, we're both partners in the firm. It's a small law firm based in Wellington. Our core work is helping people make civil claims against the state and faith-based institutions for abuse they suffered in care as children or as vulnerable adults. Today, we'll talk about a number of themes that have arisen out of our work. First of all, the beginnings of the civil claims against the state for abuse in psychiatric hospitals and social welfare care. We'll also talk about how those claims grew and how the state responded, and that was with a mixture of listening forums and also fierce and uncompromising defence in the court. We want to talk about how state mechanisms such as the courts and legal aid played a role in the claims process. We want to then talk about how the role of our human rights law, both national and international, played a part in progressing the civil claims. We will touch briefly, and it will be only briefly in this part of the hearing, on the settlement processes, both current and past, and why they're not fit for purpose.
And just pausing there, apart from to say your pace is excellent, thank you. As you know, the Commission will be coming back to the topic of redress, including settlement processes, in March next year. So there will be some points where you leave further detail for March, is that right?
Absolutely. I mean, we could probably talk for some days about the settlement processes, and hopefully we'll get an opportunity to talk at length, but this is really just to set the scene. We wanted to talk about the disadvantages experienced by many survivors, and they include less access to information, particularly information about themselves, fewer resources to obtain help, often poor literacy or mental health and economic circumstances which pressure them to accept compensation and settlements which do not reflect in any way their experiences. And briefly, I think at this stage, what we see as the way forward for the claims process as part of a larger truth and reconciliation process. First of all, I just wanted to address the language we're going to use. Often we talk about victims of abuse, but we want to talk about the people that we meet and work with in a way that we think and hope is empowering. We're going to use the term survivors, or ngā morehu, or care leavers, to discuss the people who experienced abuse in care. We want to put those people in the centre of what we talk about today and what we do as a firm, but we know that every experience is different, and just as survivors cannot speak with one voice, we can't speak to all of their experiences today. We acknowledge, obviously, those care leavers who have already spoken to the Commission and will speak to you. We don't and cannot stand in their shoes. During the course of our evidence today, we're going to talk a lot about civil claims. So these are the claims that we take, which are in tort, which is part of law, obviously, or the human rights legislation. Mainly our claims are against government departments, which were responsible for the care of children and vulnerable adults. Most of our claims are directed to the government because it is liable for the actions of people it employed or contracted, and that's something we'll talk about in our evidence, to do its work. We also work on claims against faith-based organisations and other organisations which provide services to children and vulnerable adults. We don't take claims against individual government employees, and we don't take criminal claims either. One of the things I think that's important about language, and we heard it a little bit in the Crown's opening statement by Wendy Aldred, is that the state will often refer to itself as the Crown, which suggests that it is a single entity. But the responses that we've experienced by different parts of the Crown have been very different, and there is no single Crown response to abuse of those who've been in care. The Ministry of Social Development, or MSD, is the government department for all civil claims for abuse in the care of child welfare, as it first was. That was up until 1972. Social welfare, 1972 to 1989. Then Child, Youth and Family Services, and it had various names during that period, which was the entity caring for children up until the creation of Oranga Tamariki in April 2017. Now, when we first did our evidence, Oranga Tamariki was saying it would be responsible for all claims for children who were in care from January 2008, but it had no process to do it, and although we had several meetings, nothing developed. We took the position that because Oranga Tamariki didn't come into being until the 1st of April 2017, that legal responsibility lay with the Ministry of Social Development. As I say, in the 2 months since we have written this brief, MSD and Oranga Tamariki have now agreed with us, and now the Ministry of Social Development will deal with all claims up until people came into the care of Oranga Tamariki from 1 April 2017. So we now know there is a single process to deal with claims up until the being of Oranga Tamariki.
Just pausing there, for those later reading the transcript, that means an update to paragraph 7.
It is.
Thank you.
I do note it is a sad fact that Oranga Tamariki will be a defendant in its own right eventually as survivors continue to come forward. And I just comment there, in my day-to-day practice as a youth advocate, I would say that virtually every young person I act for in the youth court has a potential claim already at this stage, which is a very depressing thing to say. The other two main defendants that we deal with are the Ministry of Education and the Ministry of Health. The Ministry of Education deals with civil claims by people who were abused in some state or special residential schools. So Waimakoia, Mackenzie and Salisbury School are some examples. Sometimes the Ministry of Education is jointly responsible for a claim. So, for example, Campbell Park School, or Otokaiki, as it's known by our older clients, was a special school near Oamaru, which was run by people who were employed by both the Ministry of Education and Social Welfare. The Ministry of Health responds to claims about abuse for people who are in psychiatric hospitals, so that includes Porirua Hospital, King's Seat, Lake Alice, only where that abuse happened before 1993. And very recently, and again, one wonders if that's a challenge from the Royal, to a response to the Royal Commission, the Ministry of Health has said it will deal with claims of abuse in general hospitals, again, so long as that happened prior to 1993. After that date, you are stuck dealing with the individual DHBs, and that's problematic. Who do we represent? Currently, we have around 1,250 clients, about 1,400 open files, and growing. This difference reflects the fact that some people have multiple claims. For example, a client who was in the Ministry of Social and Civics Care may also have been in a special residential school. Some clients, particularly our older clients, may have been a state ward who was placed into somewhere like Campbell Park, run by the Ministry of Education, and may also have had faith-based care as well. So they may have gone through orphanages or into a Catholic school, for example. So some clients may have as many as 3 claims. Our clients vary in age from 18 at the youngest to 80. The claims in the main cover the period from the 1950s through to the present time, although the majority are for abuse that happened during the 1970s and 1980s. However, as I'm going to note, the number of claims after 1980 is growing. Of our client group currently, about 17 are under the age of 22, and over 135 clients are under the age of 30, and around 300 were in care after 1999. So that, and they're theoretically at the moment excluded from the express terms of reference. So that's important to note. We estimate that already we've settled around 1,100 claims against the Ministry of Social Development, Education and Health, as well as faith-based organisations. To date, our clients have been paid settlements totalling $22,775,000, which does include a contribution to their legal costs. And we note here that while no amount of money can heal some wounds, we would say that no survivor to date has received adequate compensation for the harm that has been done to them, and we say that unapologetically. Of course, the figures that we can say do not include payments made to those who are self-represented or from the small number of other firms who've done this work. Only the state and the churches can provide that information. It's important to say that most of our clients are vulnerable in some way. The vast majority are either beneficiaries or low-wage earners in precarious economic positions. Around 40% of our clients at any given time are prison inmates. Almost all of them experience mental distress or ongoing psychological and other effects from their childhood or adult care. And as has been noted already during the course of this hearing, our clients are disproportionately Māori.
Ms Hill.
Thank you. I want to address the Commission on what state care means and talk about some of the terms that we use in the course of the civil claims. And in our work, we talk a lot about legal status and the legal status of a person who is in care, because their legal status defines their relationship, particularly with the state, and how they could be treated. So many children came under the purview of social welfare while they still lived at home. Sometimes this was due to notifications of abuse or neglect or poverty, or because the child had committed offences. Many Māori children were prosecuted for the misdemeanour of stealing milk money. Many Pākehā children were not. The courts have held that if social welfare received a notification of concern about a child, such as physical or sexual abuse, a duty of care arose between social welfare and the child to investigate it. And preventive supervision was an administrative mechanism developed by social welfare, in their words, to prevent children becoming casualties. So it often involved regular visits to a home by social workers, emergency financial assistance, and visits to a child's school. So preventive supervision was different to legal supervision. Legal supervision was imposed by a court, often in response to a child not being properly supervised by their parents or for offending. At times, social welfare would receive reports or notifications of abuse or concern about a child and fail to act. Sometimes the reports piled up about a child or their family, particularly about abuse in home environments, and still nothing happened. And this is still a major problem today. In contrast, other children, particularly Māori children, were removed from their families, sometimes for years, often just because the family were too poor. So I need to emphasise right now that state care wasn't just being taken away and put somewhere else, that state care can be being at home with your family, and it was just as important to look at that time and look at what was happening for a child and their family before they're removed. It's not just about the institutions and the foster placements. So many children came into care by way of complaint action. So that was a complaint by either social welfare or the police that a child was not under proper control or that they were living in a detrimental environment. And that would often pave the way for a child to be placed in care and then under the guardianship of the Director of Social Welfare. And much like an adult, a child could be remanded in care while a complaint went through the court system, and they could be taken and put into care at that point. Sometimes children were voluntarily placed in care by their parents or their caregivers. Sometimes that was for a month, sometimes a year, sometimes up to 2 years. And there were differences in the way a child under a voluntary agreement could be treated while they were in care. And we'll talk about secure units a little later in our evidence. But a child under voluntary agreements could be placed in institutions, family homes, or foster care in the same way as a state ward. And a state ward is the common term up until 1989 for a child placed under the guardianship of the Director General of Social Welfare. Being a state ward meant that social welfare had total control over a child. Social welfare controlled where they could live, where they went to school, where they could work when they got older, how much money they were able to earn, and where they could travel. A person was often discharged from guardianship at the age of 17, but could remain a state ward until they were 20. Many children who were under the care or custody of social welfare were also placed in faith-based institutions by social welfare, And so sometimes the line of responsibility for a child was blurred. After 1989, the whole scheme changed. And there are plenty of historians and sociologists who will talk about the changes that brought about the Children, Young Persons and Their Families Act 1989. And we'll just call that the 1989 Act. That was a drastic departure from the earlier Children and Young Persons Act 1974. It brought in new language, new principles, and new schemes for dealing with children in care. And it separated, some would say quite arbitrarily, the ideas of youth justice and care and protection. And in our experience, those two things are intertwined. The 1989 Act provided a scheme for the family court to deal with care and protection issues with the ability to place a child in the custody or guardianship of social welfare. No one is SIPs by that time, obviously. And youth justice provisions went through the youth court. And that mainly dealt with children between the ages of 14 and 16 who had committed offences, although, as Sonia will tell you in her role as a youth advocate, the 1989 Act continues to criminalise younger children in certain circumstances. Decisions were made and are still made by Family Group Conference, or FGCs. Now, the plans drawn up by FGCs often had a range of activities and a range of outcomes for a child. Children and young people could be sent to programs, put into care, placed with whānau, or made to do community work and so on. And some children never saw the inside of youth court if they could complete their plans. So these changes were considered to be quite revolutionary at the time. And the family court and the youth court worked together, but often not very well together, I would say, and often had quite disparate outcomes. So, while the 1989 Act was considered to be world-leading and extremely progressive, in our experience, the social workers on the ground took a long time to catch up. Children in care in the transitional period between the late 1980s and the first few years of the 1990s, they really fell through the gaps. In our experience, social workers struggled to adjust. Resources were not available. Almost always, the records for people in care during that time period are incomplete and inadequate. Important aspects such as FGCs were not used properly, although that's still a problem now. Another important change which happened after the 1989 Act, of course, was the introduction of the New Zealand Bill of Rights Act 1990, and that came into force on the 25th of September 1990. And from that date, children in care had additional rights under that legislation, and we say the state had additional responsibilities which overlaid the 1989 Act, and we'll talk more about the Bill of Rights Act later in our evidence. One of the important aspects of the 1989 Act was an approval scheme which allowed SIFs to use third-party programs or organisations to care for children. And the approval scheme is triggered by Section 396, and so often to shorthand things, I call them Section 396 programs. So this meant that third-party organisations, which could be incorporated societies, iwi organisations or charities, had to meet a certain level of approval to provide services, and in return they were paid by bed nights, or however many nights a young person was in care. And so SIFS was able to place children who may be in their direct custody with other providers, and that still happens today. The scheme under Section 396 provides for complaints to be investigated and sort of annual reviews of an organisation and their ability to care for children. Now, while this sounds good in theory, the practice occasionally went horribly wrong. The division between frontline social workers dealing with children in these programs and the organisation which did the approving was significant, and there was often no communication between the two. And so the Community Funding Agency, which was the organisation tasked with reviewing these organisations, often did it on paper, making sure they had the right policies and procedures and guidelines, but never really met the children, and sometimes didn't meet the staff. And so the social workers on the front line, receiving direct reports of concern, would be dealing with that separately, and so sometimes the two systems didn't meet in the middle. And so an organisation again and again was approved because they met the policies and procedures, but did not, but no account was taken of the individual complaints. So there was a real disconnect there. And when complaints weren't dealt with properly, further abuse was inevitable. And I'll talk more about whakapakari, Moerangi Treks, the Eastland Youth Rescue Trust, and the Heratanga Māori Executive as some examples later in our evidence. And using these organisations at times has caused the Ministry of Social Development to say, we're not liable for that. That's separate. They're contractors. Even where the children are in their direct custody or under their supervision, and where it was able to approve or suspend the approval of the organisations. And this was a position that the Ministry had for quite a long time. And it meant that for a group of survivors, the settlement of their civil claims was affected by that because large chunks of their experience were discounted. And so they settled their claims based on that, and settled their claims poorly sometimes. And since then, the Ministry has changed its position and has, while not expressly, but for the purposes of settlement, has accepted responsibility for many third-party organisations, leaving that earlier group of people disadvantaged.
I take it there's no way for that first group who settled many years ago to reopen their claim despite the change in the Crown's approach.
They have signed full and final settlements. Obviously, the Commission, it would be open to the Commission to recommend that that could be reopened, and that's certainly something that we would support.
Ms. Cooper.
Thank you. Just make sure the light is glowing. I'm now going to talk about our experience with faith-based institutions. So the experiences of people placed in faith-based institutions were often very different from those who were in state care. Very young children were sometimes placed in orphanages or foster homes run by faith-based institutions. Some examples of this included the Nest, which was in Hamilton and was run by the Salvation Army, or we've got Catholic-based orphanages such as the Star of the Sea or the Home of Compassion. So we're looking back typically quite far back in time. So we look as far back as the Infants Act 1908. There, anybody who had a child in care under the age of 6 had to be licensed as a foster parent. And then under the Child Welfare Act 1925, any child could be detained in an institution, which did include some private institutions, including faith-based institutions. We had clients who were placed as sibling groups in Whatman Home in Masterton or Bramwell Booth Home in Temuka, which were run by the Salvation Army. The Salvation Army also ran Hodderville, which was a home for boys in Aotearoa in Auckland. And we also dealt with the Auckland Trust for Women and Children, who ran Brett Home, Stoddard House and smaller cottage-style institutions.
I think you accidentally said the Auckland Trust. Was that the Anglican Trust?
Sorry, the Anglican Trust, yes. The Anglican Diocese of Waiapu ran Abbotsford Home in Waipukurau, and that also operated for many years. I think it's important, and I've referred to that earlier, to say the crossover between state care and church care, because a lot of state wards ended up in these placements. Families also placed children there privately and paid maintenance if they had the funds. Where a child was placed in a faith-based organisation by the state, then board was paid to the institution for the care of the child. And social workers were supposed to visit regularly, although that often fell by the wayside, particularly if the placements were remote. And Hodderville, I think, is probably a good example of that. Then the psychiatric hospitals. Patients going into psychiatric hospitals either went in there as voluntary boarders or informal patients, or as committed patients under the relevant mental health legislation. We also had clients who were admitted under the Criminal Justice Act, so that's when they'd been remanded by the courts on a criminal charge for assessment. Informal patients, which was something we needed to test through the courts, ultimately were found to have the right to refuse medical treatment, which is something we'd said all the way through. At this point, I just want to set out what our clients told us through the years about what happened to them in care. And again, we've had to take a broad brush here. By far, so dealing first with psychiatric hospital, and this is children and adults. I should say predominantly our clients were children. So by far the most common complaints in psychiatric hospitals were of severe physical assaults, and that was not only at the hands of other patients but also at the hands of staff, and that included being punched, kicked, hit. One thing I vividly remember from Aotearoa Hospital was our young boys particularly talking about a favourite punishment called the concrete pill, and this is where 4 staff members would hold a teenage boy by each of their limbs, haul them up and then drop them on the concrete, and that was a common treatment of young boys at Aotearoa Hospital in the 1970s particularly. Our clients were also sexually violated and abused by staff and other patients. Many were given what we call unmodified ECT. So unmodified ECT is where you're given electroconvulsive treatment without any anaesthetic. So the usual way of getting ECT is with an anaesthetic and a muscle relaxant to stop any pain, but a lot of our clients talked about getting it without either of these, so they did experience pain. They were also given ECT as punishment, and again, this is mainly teenagers that we are talking about. Teenagers again mainly, but this also happened to our vulnerable adult clients, were pulled into the ECT rooms to watch other patients being given ECT to frighten them, and were told, you know, this is what will happen to you if you don't do what we tell you. Clients talk about being given painful injections as punishment. One particularly painful injection was paraldehyde, which was so poisonous that it actually had to be administered through a glass needle that was very thick. And again, a lot of clients were given that regularly to punish them. Again, they complain about being put in seclusion rooms, and the seclusion rooms were fairly barren, awful circumstances. Others, particularly children, were placed in psychiatric criminal wards with adult patients who were severely disabled and unwell and terrifying for teenagers to get them to do what they were told. Now up there we've got a photo of Rauta Ward. This is one of the dormitories in Aotearoa Hospital. So this just gives you an example of a psychiatric hospital ward during the time frame that our clients would have started to go into Aotearoa Hospital. So you can see how barren it is. There were other complaints that we've had of traumatic incidents, such as being actually hosed down by nursing staff, being threatened with a lobotomy, and being told that they would never leave the hospitals. And I actually interviewed a client last week who's in his mid-70s who actually described to me having a hose pushed up his rectum for 4 or 5 days and water flushed through it, purportedly to see if he had any drugs, but it was a torture and a punishment for him. The picture that's now up there is I think it's the outside view of F Ward, which is also at Aotearoa Hospital. So this is again a kind of bigger picture of Aotearoa Hospital. F Ward was the women's ward, the criminal ward, and again, a number of our clients, teenage girls, were put in F Ward as punishment, and when we give evidence, when we hear again on Thursday, the client whose evidence I will be talking to talks about her placement in F Ward as a 14-year-old and the terrifying things that happened to her there. One of the clients that we had describes that it was common to get clouts, kicks up the bottom, verbal abuse and threats of ECT from nursing staff. This would happen if I didn't do my jobs properly, like polish the floors. It was just an everyday experience to witness staff physically abusing patients. And as I say, I'll be speaking to evidence of Beverly Wardle-Jackson on Thursday, who was there at Aotearoa Hospital, and talking about her powerful experiences there. I then want to talk again and summarise the experience of our clients in social welfare, and that goes through the ages in SIFS care. To be honest, it's impossible to summarise that, but all we can do in this evidence is give you some examples to demonstrate what we say has happened to entire generations of children who've been placed in the care of the state. We've tried to reflect the range of experiences and the demographics of our client group. If we don't talk about an institution or a placement, it's not because it didn't happen, it's just because we can't cover everything. So first of all, Amanda's referred to family homes and foster placements. Social welfare family homes were spread all around the country, and they still exist to this day. The house parents often varied, although some remained house parents for a long time. The idea behind a family home was, as the name suggests, that it was a family home, and there would be 5 or 6 children living in an environment that was intended to be like a family. Lots of our clients say that the people who ran the family homes were well-meaning, but either didn't have the tools or the skills to cope with what were often groups of difficult children. One of the common themes is that there was no supervision at night time, and I think that's probably still the case, and so physical and sexual abuse between children was a regular feature of those who stayed in family homes. Also too, as I've commented on, the abilities of family home parents varied a lot. Some had very positive reports and others had a long history of violence or just allowing bad things to carry on. And a number of family home caregivers are the subject of allegations of physical or sexual abuse. One of the things that we noted, and it's still a common theme today, is that it's common to see the grown or older children of the family home caregivers acting as relieving caregivers, or in many cases acting as enforcers of the rules. And clients often tell us that the grown sons and daughters of family home or foster caregivers would be the ones dishing out violence to keep the children in line. And I worry about that still. With foster care, there are many foster parents who are spoken about with appreciation and admiration by our clients. Unfortunately, long stays at good foster homes were rare. Like many foster children, and including those who are in care today, children in the foster care system experienced multiple placements, and that impacted obviously on their ability to settle, to adjust to school, to make friends, and to feel safe and secure. Sadly, many of our clients talk about the physical and sexual abuse they suffered at the hands of their foster parents. And I think what's particularly disturbing is that a common theme is that their attempts to disclose this to their social workers or other people were met with disbelief and or punishment for lying. It was exceptionally rare for a child to be believed and for action to be taken. Usually action was taken only if a second person, usually not a child, could corroborate their account. But our experience is that more often than not, complaints went ignored and abuse continued, and for some clients that abuse went on for years. So then I'll talk about social welfare and SIF's residences. Boys and girls' homes were spread throughout the country. Some operated as remand homes like Lookout Point or Stanmore or Wairaka, Ipuni. Others were national long-term training institutions, and probably the most well-known were Hokio and Kohitiri. Several staff members from different institutions have been convicted of sexual abuse against children, and we've set out in Appendix A a list of all the ones that are known to us. So that's 28 people that we were able to identify who've been convicted of sexual offending against children in their care. And they cover a range of placements, so not just state care, they also cover religious clergy, Salvation Army caregivers. I think what struck me about this is how many of the prosecutions are relatively modern. In other words, they've happened within the last 20 or so years, even though the abuse occurred potentially decades earlier. And that is something I want to comment on later on in my discussion about why it takes so long for survivors to come forward and talk about their abuse. We know that our list is by no means complete. Even as late as last week, we were told of an Anglican archdeacon, I think from Nelson, who'd been prosecuted for sexual offending. We had no idea he'd been prosecuted until last week. But I think there is an assumption that we know. We actually don't. This information is very difficult to come by, and I know when we did our trials, the Crown actually wouldn't disclose this information to us. We actually had to get it ourselves. So even though I think, there should have been an obligation to disclose that to us, it was shrouded under legal professional privilege. How that's privileged, I don't know. And as I say, we were told by the court we had to go and find it ourselves, and so we did.
Just pausing there, we won't ask you to go through the whole list, but for those who've got the written statement, Appendix A is at page 50, I think, and we have 2.5 pages of those who have convictions to your knowledge.
Yes. And as I say, they cover a range of placements, sort of Ipuni and Hokio, a few from the Hiratonga Māori Executive that Amanda will talk about. There's a girls' home caregiver, a family home caregiver, Salvation Army, Catholic boarding schools, Ministry of Education, special residence teachers. So it covers a wide gamut, and as I say, I suspect there are a lot we don't know who've been convicted who should be on that list. Hopefully the Royal Commission can get that information. And I think one of the points of just showing that there is this kind of growing list of convictions is to say that that really only tells one part of a wider story, because all too often staff members who were found to be abusing children were permitted to just resign from their positions without there being any referral to the police, or worse, were shifted to another institution and were allowed to abuse children there. And we're going to talk about some of those examples in this evidence, because, in some examples, those staff members were actually promoted. So we give one example, first of all, of a caregiver, Mr. S, who was a staff member at Campbell Park School. In January 1970, he was suspended because there were allegations he'd been sexually abusing boys. So 3 different boys at Campbell Park School made allegations between March and August 1969. Records that we have recorded that S had taken boys to his home on many occasions, sometimes at night when his wife wasn't at home. A rubber penis had been found concealed in the ceiling of his home. A train set was used by him to get the boys to come to his home. He showed the boys pornography. He paid one of the boys for a photo of his sister. And as we commonly see, he denied he'd done anything. He told the then principal, Mr. Walsh, that a number of years earlier another boy had made allegations against him, but the then principal, Mr. Connor, hadn't believed him. This is a typical case in which the police decided not to press charges because they thought the boys wouldn't do very well under cross-examination, and he was allowed to resign from Campbell Park. We also had it brought to our attention that in 1979, as part of a Human Rights Commission inquiry, a staff member complained to the Human Rights Commission that several staff members had been shifted or promoted after allegations had been made against them. And just note up there, this is Campbell Park School, or Otakaiki, which was really isolated and run by both Ministry of Education and Ministry of Social Development. I know that Oliver Sutherland has already talked about some of these shifting around of staff members. So we're just going to speak to a couple of examples. So one example is that documents show that a Mr. Zagarlo had been shifted from his post as principal of the Margaret Street Girls' Home in Palmerston North following an indiscretion with an inmate, so with a girl. He was later promoted to be principal of a boys' home after spending a number of years in Hokio. In 1978, the principal of Bollard Girls' Home was hurriedly transferred to Holdsworth School, and this was another person who had alleged misconduct with a girl, and so he was hurriedly transferred, and he was later promoted to principal of Holdsworth. We're going to give an example of one staff member, Mr. Drake, who was another staff member in our experience who had many allegations made against him. And so we've gathered information about his movements over several years. So he began working for social welfare in September 1958, starting at Hokio. He then was promoted and went to Aotearoa for 2 years, back to Hokio, and then he went to Campbell Park. In 1971, he was again promoted and went to Holdsworth School as an assistant principal. And this was under Mr. Perversia, who was then the principal. When Mr. Perversia was transferred to Auckland, Mr. Drake was acting principal for a few months, so the top of Holdsworth, until Michael Doolan was appointed as principal in late 1975. And Mr. Drake is a staff member who was able to continue in his job until he resigned. During the time he was acting principal of Holdsworth, he was investigated because there were multiple allegations made that he had been sexually abusing boys. The investigation was done by the controller of the National Institutions, Dennis Riley. If the outcome was documented, it's never been found. We've certainly never seen it. And the only reason we really know about it is because in an inspection report in March 1975, it was noted that Mr. Drake now keeps his distance from the boys, and this affects both his work and his job satisfaction. So the allegations against Mr. Drake were again raised in July 2004 by a client of our firm. 3 years later, a team from the Ministry of Social Development and Crown Law interviewed Mr. Drake. In the same year, a police complaint was laid. At around the same time, the Ministry of Social Development told the police that 5 other former students of Holdsworth had made allegations against Mr. Drake. The police inquiry took about a year in terms of interviewing other staff members from Holdsworth, some of whom indicated they'd had concerns about Mr. Drake based on what they'd heard from other children. The police only spoke to Mr. Drake in April 2009, so 5 years later, by which time he was determined to be too unwell to make a statement. However, we note rather cynically he was well enough to swear an affidavit for the Ministry of Social Development a few months later. In the course of settling the historic claims, the Ministry of Social Development has accepted allegations of sexual abuse by Mr. Drake, but only at a lower level. And I mean, the allegations against him go right through to rape, but they've only been accepted at a low level. And this is in spite of the very strong evidence being against Mr. Drake. We then refer to the cook at Hokio, Michael Ansell. Again, he's an example where complaints were ignored, because again, there were lots of complaints made by boys at Hokio that he was sexually abusing boys. Here's an example too.
Yeah, I think we have a photograph, do we, of the
boys
lined up in a semi-military style.
There we go.
1960s.
Yes, that's right. So, I mean, that's something that we'll talk to, is some of the kind of rigidity around the boys homes and some of the punishments standing on the line, this would be a good example of that. Going back to Michael Ansell, one of the things that came out in discovery was that if a police check had been done before he was hired, it would have shown that he had convictions for sexual abuse in 1969 prior to actually working at Hokio. He was eventually convicted of indecently assaulting boys at Hokio, and in our view, that abuse could have been prevented in its entirety. Another staff member at Hokio was disciplined for assaulting boys and dismissed after he was charged for sexually abusing boys. And I think one of the things that became very clear to us in our work is that in each case, police involvement was a last resort, not a first response. And in fact, the first response was typically shift or allow staff members to resign. And these are only some examples of staff being shifted or complaints not being dealt with properly, which exposed vulnerable children to further abuse. And it also reflects the very long time that police would take to investigate historic claims. And I think certainly back in the 70s, 80s, even 90s, I think it reflects that they weren't deemed to be important enough cases. We also want to talk about the more insidious kind of assaults, sexual assaults, which were often under the cover of medical examinations. So, for example, we talk about the doctor who visited boys at Wesleydale and Oaraka, who was known by the boys as Dr. Cough, because he would make the boys remove their clothes, he'd line them up and see them individually, he would make them remove their clothes, and he would touch their genitals. And so he developed the name of Dr. Cough. And these medical examinations were completely unnecessary, but they went on for years, and many of our clients talk about them. We also highlight, and I think Dr. Sutherland's probably already referred to this, the issue of internal vaginal examinations, which were conducted on girls throughout the country, and in particular at Bollard and Allendale, internal examinations were conducted purportedly to establish if a girl had a venereal disease. Girls who refused to be examined were severely punished, and in fact, I think I vividly remember writing recently an offer letter for a client who was held down as a little girl, held down by a number of staff members, so this intrusive vaginal examination could be conducted. So a court made a complaint about this in February 1979. I just note that in recent correspondence that we've had regarding one of our clients' claim, MSD has refused to accept the allegation that she had an improper vaginal examination on the grounds that that was the policy of the day. And I have to say that that is a way in which liability is frequently avoided on the grounds that that was consistent with the policy of the day. And I think that in light of the work that was being done by a court back in the late 1970s, to still argue that does not really have much credibility.
Ms. Hill.
I wanted to talk about what we've commonly called a culture of violence at institutions and placements around the country. And a lot of what I'll say is focused on social welfare institutions, but the similar cultures existed, of course, in faith-based institutions and in psychiatric hospitals as well, so the comments are equally applicable. And I have to say the phrase a culture of violence is used in MSD's description of some of its own programs and placements. It's not a phrase that's always been coined by us. It certainly has appeared in a number of documents about placements and programs used by SIFs. So there was first a culture of violence, and this was coupled with a prohibition on narking or snitching. And so the culture, these two things went hand in hand, that there was violence, you don't talk about the violence, and if you do talk about the violence, you'll experience worse violence. At almost every institution, our clients have talked about welcoming or initiation or christening beatings. So a new admission to a residence would be beaten up by the others, often at the direction of the oldest or biggest among them, and I think for decades that child or young person has been referred to as the kingpin. Now these weren't separated from the staff. The staff encouraged a culture of violence and this kingpin hierarchy, and they knew that these beatings took place. Sometimes they were done with staff members present, other times staff members would walk away. At Hokio, for instance, the boys always went over to the sand dunes. No staff members ever went. At Koatiri, sometimes the beatings would be in the dormitories at night, where boys would put hard objects in a pillowcase and use them as a weapon. At other times, the work boys, the boys out on the farms, would use their steel-cap boots. And there were names for the different levels of boys, depending on what time you were there. You could be a hard jub or a nah boy, or these different levels. Then you had to work your way up, because it wasn't just that first beating. You had to fight to survive. And the kingpin was the one who was the one out on top. And they enforced that kingpin hierarchy by forcing that violence downhill. And initiation beatings rolled into regular beatings and regular violence. And sometimes discipline was kept by the kingpins at the direction of staff. Kingpins were privileged, they were given sometimes more food, more freedom, but their job was to keep the younger ones in line on behalf of the staff members. And if you disclosed, if you narked, then further violence would inevitably follow. And virtually every client we have spoken to who has been in these homes can name the kingpin and can say, I don't want to be a narc. And that culture is still there now. And kingpin hierarchies, they've existed in one form or another since the institutions have opened. It's a form of survival. And they're not a thing of history. So on the whakapakiri program on Great Barrier Island, which closed in 2004, the kingpin hierarchy was formalised. They were called the flying squad. And the flying squad were the 2 or 3 oldest and biggest boys appointed by the staff, and part of their job was to chase boys who tried to run away and to beat them, and to drag them back to the main camp, throw them on a boat and take them to a small island called Alcatraz. And yeah, and actually I've got a still here from a movie when the photos come up. Oh, was it up? Oh, I wasn't looking. So there we go. And just going backwards a bit from whakapakiri and back to Kohatiri, Tere, in 1985, a movie was made at Ko Tere. In fact, there were 3 movies. This one's the most well-known, and it's called Kingpin. And in 1985, a group called Morrow Productions made this movie using boys who were being held at Ko Tere at the time. And that's a still there of a guy, he's beating up on a younger guy, a newer guy. And actually, if you watch the movie, and you can watch it, a part of it on the New Zealand on-screen website, and the bit you can't hear in the movie is him saying, don't be a hard jube, don't try to be a hard jube. So don't try and be above your station. And so the movie shows a little of what life was like at Ko Tere at that time. So I was talking about the flying squad and Alcatraz. And the other part of those flying squad boys, the other part of their job was to go to Alcatraz, which was a little rock off the main camp, Great Barrier Island. There's no shelter, and boys were taken there as punishment. And the flying squad's job was to stay there with the boys being punished and supervise them. But obviously, supervision meant beating them regularly during that period of time. And at certain times at Whakapakiri, there was a second tier of top boys. So they were the deputies, and they were called junior leaders. And these are referred to in people's records, junior leaders. Oh, I've made the flying squad, it's a really good thing. One of the big driving factors about the flying squad actually was that they got more food. In Whakapakiri, there was never enough food for the boys, and so one of the factors driving the flying squad was hunger. So these are phrases regularly used in reports back to SIFs, and in one set of records, a Whakapakiri staff member described the junior leaders as being like tribal policemen. So it was commonly understood in the institutions and programs that if you disclosed abuse, you'd be further punished. And that environment has been perpetuated for so many years that it's still part of our clients' lives now in prison, where narcs are still beaten in prison and you don't talk to the police or to the authorities. And in our current residences, our children in care now. In 2017, the Children's Commissioner issued a report, State of Care 2017, and in it they used the phrase, snitches get stitches, and that's 2017. So in a photo that might pop up, or may have already popped up, there'll be there we go. So that's a boy standing on the line. Now that was a regular punishment. It's at Hokio, I think, at Apuni. Standing on the line was a regular punishment in the institutions, and I wanted to use that photo to demonstrate the wide-ranging psychological abuse that was present in institutions. So we talk a lot about physical and sexual abuse because these are what people understand more about what abuse really means. But psychological abuse and emotional abuse were just as harmful and just as prevalent. So children in care were told that they were useless, that they'd end up in prison, that they'd never amount to anything, that their parents didn't love them, that nobody wanted them, that they were worthless, and nobody cared what happened to them. And so many of our clients heard that for so long, and they talk about how they absorbed that, and it became part of their own self-belief. And standing on the line, punishments like that wouldn't just be for 5 or 10 minutes. That would be for hours. And that would be in the rain, and that would be while staff members and other boys would continuously, verbally and sometimes physically abuse them. And I think Arthur Taylor, when he gave evidence last week, talked about standing on the line. So there's different variations of things like that around the institutions. Standing facing a corner. Holdsworth had a dog box. You had to sit in the dog box. So lots of these things where you were isolated and on show as part of your punishment. And part of the psychological abuse and part of the enormous impact of institutional care is solitary confinement. And there's different words for solitary confinement. Seclusion is one that's used in the mental health context a lot. Solitary confinement or secure care. And some of the photos that will come up will show you a secure room at Hokio, for instance. There we go. And there's nothing in the secure rooms at Hokio. They were just two little lock-up cells. So this was a significant part of institutional life at the boys and girls residences. Most remand centres and all national institutions had secure units of some sort. And so being placed in secure meant 23-hour-a-day lockdown. And at a lot of the boys' homes, that 1 hour out was for extreme physical training. The photo up there that's just flashed up and gone again, there we go, is a boy inside a cell at a Puni. That looks quite well furnished, so I don't think it's a secure unit cell. I think that's your average everyday room. So there's nothing in secure unit cells. The bedding and the mattresses were taken out during the day, and a boy had nothing but bare concrete, shorts and t-shirt. And as I say, 23 hours on your own, meals in your cell, no one to talk to, no schoolwork, no activities. And punctuated by this really harsh physical training, carrying things while duck walking, really heavy things for often really little kids. Duck walking, push-ups, sit-ups, running, all while being verbally abused and physically abused by staff. Now, after 1989, the standard amount of time for secure care was about 3 days, and then you have to go through a particular process. But before 1989, there weren't really any rules about the use of secure. And so lots of children were put in secure as a matter of course. It doesn't matter why they were being put in an institution. They did 3 days in secure, just to sort of introduce you to the environment. And that was later found to be a breach of policy, that they couldn't do that, but they kept doing that for years. And other children were left in secure care for extraordinary amounts of time. One of our clients spent a total of 99 days in one stretch in the secure unit at Oaraka. In 1986, regulations came into force, the Children, Young Persons Residential Care Regulations 1986. And so the intention behind those regulations was to provide a bit more structure about the use of secure. So those regulations required things like daily reviews of a residence placement in secure, that education or recreation had to be provided, that they shouldn't be regularly confined to their rooms, and so on. In our experience, those regulations were routinely ignored. And importantly, if a child is placed in an institution under a voluntary agreement, and right back at the beginning I explained that children could be put in care voluntarily, those children could not be put in a secure unit. Unfortunately, that wasn't clear for a number of years, and children in voluntary care were held insecure, and there was no lawful basis for that. And that was only clarified when a document was sent out and circulated to institutions in February 1987, and that confirmed there was no legal basis to detain children in secure when they were there under voluntary agreements. But time and again we have seen that happen after 1987. So despite the circular, children went into secure because I think once they got there, no one really looked at what their legal status was. They were just another kid in the institution. And that same document confirmed that children who were admitted temporarily or informally or under a warrant or under the Criminal Justice Act, they couldn't be kept in secure care either, but the same problems arose. And I want to draw the Commission's attention to a report called Thinking Outside the Box, a review of seclusion and restraint practices in New Zealand. That was done by Dr. Sharon Shalev in April 2017, and it dealt with the use of solitary confinement and secure in not just SIFS residences, but in mental health institutions and anywhere else where people could be detained. And one of the things it emphasises is the extraordinarily adverse impact that solitary confinement has on any person's mental health, but on a child or a vulnerable person, someone with mental illness, for example. Solitary confinement's devastating. And so I really commend that report to you. And I think there was a photo up that we had that showed an obstacle course at Hokio. It may have already flashed up, but there it is. And we've included that one. It's a rather wholesome looking photo, but the reality was that the physical training, the punishment physical training, was extremely harsh at all of the institutions that we've looked at.
And just for the record, it shows a log across a
yes,
screen.
so boys clambering across a log, and there'll be staff members somewhere there making sure that the boys go as hard and fast as they can. I wanted to turn to the issue of practice failures, and that's a phrase that we use a lot in our work, and it's shorthand, I guess, for social work practice failures. So, of course, social workers and state agencies and social workers who work for faith-based institutions as well, they were governed all the time by practices, policies, manuals, guidelines. No matter how far back we go, there was always rules and policies.
This is something that Judge Henwood talked about on
Absolutely.
Tuesday last week, and
Absolutely,
I recall
yeah.
her saying we had some very good policies, but they weren't always
Yes.
followed.
Yes,
And I think she took the commissioners through the set of practice failures
yes.
identified in class. It might not be necessary for you to go through all of them in 82.
That's absolutely fine. Happy to skip over those. What I wanted to emphasise, though, is that understanding practice failures is vital. And to do that, you have to be able to understand not only the policies in place, but the records of an individual survivor, and be able to match that with their experiences. And part of the work that we do is helping our clients understand what practice failures are and understand what their records show about what their social workers were doing. So it's a much more intricate thing to be dealing with than physical or sexual abuse, but it is so important because if a job is not done right or in accordance with a policy, then inevitably further harm follows. And up on the screen there is actually another still from the movie Kingpin. It's got a boy being restrained by a staff member after he's put his hand through a window. And it's just to sort of, sometimes boys did not act in their own interests, and harming themselves was one way to get out of bad situations. So, Sonia mentioned earlier about this sort of fallback phrase that the Ministry of Social Development has used previously about this was the practice of the day. And I'd strongly encourage people to not feel like that's okay. That even a practice and policy of the day doesn't make something right, and it doesn't make something lawful. So we need to be very careful about allowing ourselves to be lulled by that. I wanted to talk more about third-party caregivers and programs, and I touched a little on this earlier. And I talked earlier about the Section 396 approval scheme. And we have already identified that the approval scheme was faulty, and I think still is faulty in some ways.
It may be suitable, Mr. Mount, just as this new passage begins, for us to take, albeit slightly early, the morning adjournment.
Certainly, sir. Thank you.
Thank you, Mr. Mount.
Thank you, Mr. Chair. Ms. Hill, we were at third-party caregivers.
Yes, and I think we'll... I'd just like to summarise some of the experiences that we've heard about in these programs. And we also need to acknowledge that some of the organisations that we're talking about still exist today, and we need to acknowledge that some of them do extraordinary work and invaluable work. And we acknowledge Start Taranaki and Challenge 2000 and organisations like that who provide care and support to tamariki in a really meaningful way. So, throughout the 1990s and the 2000s, the number of programs and organisations providing care they expanded greatly, and some of them were very small, some of them were nationwide, and there were so many different ones. And one of the photos that we have for you shows the New Zealand Legionnaires Academy, which ran out of South Auckland, which sort of ran along army sort of lines. There we go. And that was there were some fairly brutal accounts out of that organisation.
These are people in military-style clothing with
military
flags
style,
and so on.
yes. So run along a military academy type of line. And the next photo, that's Alcatraz. That is the small island that boys who played up at Whakapakiri were placed on. There's no shelter, there's no fresh water, there's no food except what they could get out of the ocean. And boys would be placed on Alcatraz. Its proper name is Whangara Island, but all the boys called it Alcatraz, and they'd be placed there for weeks. So, programs that I've highlighted earlier, Whakapakiri, run on Great Barrier Island, so that started out in 1986, and there's a litany of complaints, all documented between 1989 and when SIFs stopped using the program in 2004. And these ranged from serious sexual assaults, where one young woman became pregnant to a supervisor. He was subsequently charged with sexual violation, unlawful sexual connection. Rat-infested huts, poor hygiene, ongoing physical assaults by supervisors. And at the end, the allegations became too much. After years of SIFs saying, don't place children there unless there's significant change, they had continued placing children there. The critical mass became too much, and SIFs went in and took all the boys off the island in one fell swoop. But what it also meant is that a number of allegations of serious sexual abuse just faded away. They were never investigated because the program was shut. Moirangi treks run in the really isolated parts of Ruatoki and the Uruweras from memory. Really harsh bush programs And what we heard out of that were boys being chained up, urinated on, made to stand in the river for hours while things were thrown at them, and dragged behind horses, and being shot at with firearms, beaten with the butt of rifles. Moerangi, again, several investigations. Boys are continued to be placed there. Eventually the program, their approval was suspended, and one of their key staff members, who had serious allegations against him, was allowed to start up a program down the road on the same property called Eastland Youth Rescue Trust. So a man who's under investigation is able to start up again, take on more boys, and almost immediately the allegations started again. And Eastland Youth Rescue Trust culminated in one boy being hospitalised. His injuries were so severe, and that program lasted less than a year. It should never have been opened at all. The last program I mention is the Heretaunga Māori Executive, much more recent. So the first complaints about Heretaunga Māori Executive came up in 2004. And when I was talking earlier about the two streams, the approvals on paper and the frontline complaints, this is where the disconnect really shows. Because they had their paperwork in order, they were approved most years, and even in the years where they were told they had homework to do, they were still allowed to keep children there. 3 different caregivers were convicted of physical assaults from Heretaunga Māori Executive, and it was only when the last person convicted, Peter Purcell, only when he was convicted and the manager of the program said, no, those boys are lying, did SIF stop placing children there. That was what it took. So I'll pass over to Sonia to talk about Ministry of Education.
And just for the transcript, the written statement, which will be available to everybody, has as Appendix B from page 53 more detail about these various complaints.
Yes, it does. So Ministry of Education residential special schools sadly are a growing area of work for us. Most of our work arises out of 2 residential schools, Waimakoia and Mackenzie, both of which are now closed. Just wanted to talk about Waimakoia, which has had different names. So it started its life as Mount Wellington Residential School, then it moved to Bucklands Beach, and it was known briefly as Bucklands Beach Residential School before it was renamed as Waimakoia. So the residential schools, we're talking in the 1980s through to the 2000s, they were not for children with intellectual disability, which Campbell Park was, for example. These were for children who were maladjusted or had emotional disturbance of some sort. So just by way of example, Waimakoia, so we've got children from the 1970s through to the 2000s. They have complained about physical and sexual abuse by staff, sexual and physical abuse between children, and we're talking about children who were between the ages of 7 and 13, so we're talking about little children. And often the sexual and physical abuse between residents, and I have to say that's kind of a residential school problem, went undetected or was ignored by staff. Multiple complaints about excessive use of physical restraints by staff. Children complaining, and again we're talking about 7 and 13-year-olds being locked for long times in the time-out rooms, and at Waimakoia the clients have described this as a concrete box which smelled of urine. At Waimakoia they were also confined in a small box under the dormitory, and there were just other excessive and cruel punishments that the children were subjected to. Waimakoia is an example of numerous complaints by the Education Review Office. So starting in 2005, and I think the ERO complaints continued through to 2008 until it was eventually closed down by the Ministry of Education in January 2010. Between 2008 and 2010, 3 former Waimakoia staff members were prosecuted but were later acquitted of several charges of physical abuse against children in about 2007. Then in 2009, a former staff member was brought to trial in relation to multiple charges of sexual abuse against several children at Waimakoia between 1984 and 1988. That trial had to be aborted because the staff member's health was failing, and he died in August 2009 before there was a retrial. And then in 2010, we have another staff member, Graham McArdle, who also taught at a state school, and he was convicted of multiple charges of sexual and physical abuse of children at Waimakoia in the 1980s. So that's an example of a special residential school, and of course, as I say, we have many claims against Waimakoia. We also deal with like the Colston School for the Deaf, and we deal more recently with Westbridge. So those claims are continuing. In terms of the faith-based institutions, I think we just wanted to highlight some of the, I suppose, the more major allegations. For example, with the Catholic Church, we wanted to highlight Maryland School, which was run by the St John of God brothers, and that was in Christchurch. And that's a situation where allegations came to light, a raft of convictions followed. So Brother Bernard McGrath was convicted of 21 charges in 2012. He was extradited back to Australia, and then another brother, Maloney, was found guilty of 7 charges in 2008 after being extradited here from Australia. Another brother was given a stay of proceedings because he was too unwell to stand trial. Just wanted to note Brother McGrath because after he spent time at Marylands, he worked with street kids in Christchurch in conjunction with an organisation called the Hebron Trust. And in that context, he abused a large number of street kids, I think probably all boys that we know of, and some of his convictions relate to this time period. And I have to say that that group is still very slowly coming forward. They've been incredibly damaged by the abuse by this brother. In terms of Catholic institutions, we hear about severe physical abuse that's carried out by priests and nuns, as well as sexual abuse by priests and nuns. And I think for a lot of our clients, the abuse is really about psychological abuse, tied to their beds, having their hair shaved off, being deprived of food, or being made to dress in the same uniform, and it was a uniform, being deprived of school, so it's a bit like the whole Catholic laundries. Some of the girls, for example, were made to do, iron and do slave labour essentially for hours on end, and were deprived of an education. We note here that there were expectant mothers, so teenage parents in particular. So they were in Catholic or Anglican institutions. Again, we are aware that they were subjected to quite cruel treatment. They had their babies taken away from them. Often they felt forced or were forced to sign papers giving up their children for adoption, even though they didn't want to adopt them. And that is something I hope that that story will be heard by the Royal Commission. Where children were brave enough to disclose the abuse, they were often shamed or punished. We know of some clients who were told, particularly, and that's a big thing for a Catholic, to be told you're going to hell. I think one of the things we note is that often blurred lines between the state and the church For example, at Hokio, and I don't think it was just Hokio, possibly Kohitiri and Ipuni actually, a Catholic priest was allowed to have access to the boys. He was allowed to take them out of Hokio on picnics and other activities, and there were many clients who were sexually abused by this Catholic priest on these activities. One of our clients disclosed this to his local priest in Wellington, and that priest was incredulous. He said that the best thing that the client could do was to confess, make his peace with the church, and that he was damned and not fit to be a Catholic. And that still resonates with that client to this day, and he's in his 60s. Particularly because the priest went on to make similar comments to the boy's family. So now I want to talk about how this work started for us. I started my life in New Zealand's big law firms, had a small stint at a small law firm before deciding to set up on my own in March 1995. It's fair to say that at that stage these claims were almost unheard of, and that's because we use the term historic. That's because often the claims related to events decades before, and there was a general view held by lawyers and judges that you couldn't bring them. They were stale claims and you couldn't do anything about them. And of course in New Zealand we had other legal barriers that we'll talk briefly about as well. In August of 1995, I had the privilege of being appointed as a District Inspector of Mental Health in the Wellington region, and through that work I started to come into contact with adults who'd been locked up in psychiatric hospitals for many years, who had been abused in psychiatric care, having started their life in psychiatric care as teenagers, and who were also state wards. So they had come into psychiatric hospital under the care of the state. Other clients came to me from various sources. One was a colleague who became a judge. She referred clients to me. Another one was apparently referred to me by his hairdresser. I don't know why. But anyway, people came to me from various sources, and they were people who'd suffered abuse in social welfare care. So they were people who'd suffered abuse in foster care, or at that stage, that early stage, I think there was not much in terms of residences, or they'd been taken into adoptive families where they'd suffered abuse. This was a very new area of law, as I've said, so I kind of thought, well, what do I do? I have to say I've always been somebody who thinks where there's a wrong it should be able to be remedied through the law. I was to find that that's not necessarily the case, but anyway, in those early days I was gung-ho and wanting to change the world. So I found that I had to start taking claims because the state wasn't prepared to engage with them on an out-of-court process. So my early years were spent in the High Court and also the Court of Appeal, just trying to get the law to establish that adults who had suffered abuse as children could actually bring legal claims. And that work, I have to say, in those early days was eventually successful. I just note there that part of this was also around the developing psychiatric understanding that abuse caused the same kinds of impacts as war veterans had suffered. So this also kind of dovetailed with increasing psychiatric and psychological understanding of the long-term effects of abuse. So the law was able to build on that knowledge in terms of allowing these claims to go ahead.
In terms of the timeline, the next big thing that came up was the Lake Alice inquiry, which was managed by Grant Cameron and some other lawyers there, but it was triggered, of course, much earlier, and we acknowledge Haki Halo, and we acknowledge Dr. Sutherland, who has given evidence at length about Lake Alice and the things that happened there. And in our brief of evidence, we've gone into a bit more detail about that, but I will leave that to one side, except to say that Justice Gallen, in his report, noted that most of the children in Lake Alice were placed there by state agencies. And that's a really important thing to remember, that it was the state placing people in Lake Alice. I also wanted to note that that compensation package of $10 million that Justice Gallen was tasked with allocating, that triggered quite a lot of media interest at the time, and a lot of discussion about the role of compensation to address harm. And while we recognise that the Lake Alice process was flawed in a number of ways, sadly it also represented a high watermark for compensation for individuals for abuse in New Zealand. And it also created a significant disparity between the people who had been in the child and adolescent unit in Lake Alice and people who had been in other psychiatric hospitals who had had really similar experiences. And so many people felt that their experiences in other psychiatric hospitals were overlooked. And Sonia will talk to you about the psychiatric claims.
So it was in 2002 that our firm first started doing psychiatric hospital work, and we were obviously spurred on by what had happened for the Lake Alice claimants, because most of our clients were teenagers who'd been in psychiatric hospital care and had suffered very similar things to that, to the allegations that were made and accepted by the adolescents who'd been in Lake Alice Hospital. So in that year, in 2002, the Evening Post did a story just starting saying we were doing some claims, and they showed some pictures of pretty scary stuff from Aotearoa Hospital, and so that client group, grew from 5 to 40 to 200 quite quickly. We didn't do this work on our own because I was still at that stage a District Inspector of Mental Health. I could not do clients who were still in care in Aotearoa Hospital or had been in Aotearoa Hospital. So our colleagues, Roger Chapman and Lisa McEwen, worked alongside us at Johnston Lawrence, and we split that work up. And I have to say now we couldn't have done that work without Johnston Lawrence. Not surprisingly, our client group wanted a similar inquiry and a similar settlement process to the Lake Alice group, but the Crown rebuffed that, and I have to say there was a lot of pushback on that from Crown Law. So we were forced into the position of having to file legal claims in the High Court, and at that stage, I think, in a big rush, we had to file about 200 legal claims. This was our first experience of significant pushback by the Crown, because in 2005, the Crown applied to strike out all of the claims using the Limitation Act, so in other words saying we'd filed the claims out of time, and also to the immunities in the mental health legislation that were pretty draconian to say that these claims couldn't go ahead. And it's just relevant to talk a bit about that, just as a kind of indication of the sort of mechanisms that the Crown used to argue these cases and other cases that we were subsequently involved in. So the relevant mental health legislation, and this was principally the 1969 Mental Health Act, had immunity provisions which protected staff, in other words, nurses, attendants, doctors, who were acting, and this is the legal words, in pursuance or intended pursuance of the Act. So they were protected from any civil claims unless they had acted in bad faith and or negligently. But even in that case, a patient had only 6 months to bring a claim. And of course, we were talking about events that had happened decades earlier. I think what shocked us was that the Crown unswervingly and unapologetically took the view that all allegations made by our clients, apart from what was classified as major serious sexual assaults, whatever that was, came within the immunity as treatment, and therefore all of the claimants had to apply for leave, and because they hadn't done that within 6 months of their treatment, all the claims were barred. And I can give you an example of that because these were the submissions that were made in the Court of Appeal by the Crown. For example, it was argued in the Court of Appeal that burning a teenager with a cigarette could be treatment to discourage children from smoking, for example. It was also argued that the concrete pill was a legitimate form of restraint. So those were the sorts of arguments that were made by the Crown, by Crown law, unapologetically, all the way from the High Court, all the way through to the Supreme Court over 5 years. So the Crown asked the court to somehow approach all of these allegations that were made by our clients as though they could somehow be treatment. They just asked the court to imagine that in some way these really terrible allegations could be seen as treatment, and therefore the immunities in the legislation applied. So while this was happening, the confidential forum was established, and Your Honour, Sir Anand, you were one of the chairs of that, and obviously Judge Mahoney was the first chair. And that, I think, was the Crown's response to our litigation, was to set up the confidential forum as an avenue for people to talk about their experiences in psychiatric care. And we acknowledge that lots of our clients had a very positive experience with the confidential forum. However, we received a lot of feedback that it provided no closure. There was no formal response. In fact, the panel was specifically not allowed to acknowledge anything that was being told to them. They were specifically not allowed to offer any apology, and they certainly weren't allowed to offer any compensation. Reports at that stage were limited to letters to the government, summarising the experiences of people who approached the confidential forum. And in essence, all the confidential forum could do at that stage was assist people to get their records where they existed and make referrals to counselling. And the transcripts, none of the actual backbone of that forum was ever able to be made available publicly. So in the midst of us going through this long, torturous strikeout process, we had 2 trials, one run by our firm and one run by Johnston Lawrence. So they both went ahead in 2007, which became an auspicious year for reasons we'll explain. So Kay was allowed to go ahead because the allegations were of serious sexual assaults by nursing staff, and so that fell outside, that they had to agree that was allowed to go ahead. And Jay, which was the one we argued, was allowed to go ahead because she'd earlier been given leave by the High Court, so her claim was allowed to go ahead as well. Kay failed. I think at that stage the judge was just incredulous about the allegations that Kay made because it really was not within the experience, New Zealand's experience, and I think he just found them incredible. And he also failed on the Limitation Act, which was extremely surprising because he had an intellectual disability. Jay, we got a number of successful findings, particularly that staff had physically assaulted our client and that she had been punished and that she'd had threats of punishment, but as was starting to become a common theme at this stage, she also lost on the Limitation Act because she had been able to approach ACC some years before she brought her legal claim, and apparently being able to approach ACC was the equivalent of being able to instruct a lawyer to bring a legal claim. So this was our first experience of the law starting to clamp down. As I said, we're still arguing our strikeout at this stage, and that ultimately went all the way to the Supreme Court, I should say. It was a costly exercise, totally funded by the public purse, because we, of course, were funded by legal aid, and the Crown was funded by the Crown. And the effective result was that we were declared the winners overall. The Crown was only partially successful. In the end, it got rid of literally a handful of claims, and the rest were permitted by the Supreme Court to proceed. And so that forced the Crown to start thinking about settlement of the psychiatric hospital claims from 2009 onwards for the first time. So we'd had a long run till then. Then, at the same time as we were doing this, we started the MSD claims. As I said, it was very clear to us that there was a big link between teenagers who were in psychiatric hospital care, and a lot of them were state wards, so they'd been dumped into psychiatric hospitals as children. And while the claims obviously had been dealt with for those who'd been lucky enough to be in the Lake Alice adolescent unit, the rest of the group was on the outside. And of course, their experiences in social welfare care weren't covered by that Lake Alice settlement process either. So they felt that there was this big gap between their experiences and what had actually been acknowledged. And one of the things that we note here was, again, the blurred lines of responsibility, because we have a number of clients, and that's still being talked about today, who were at Holdsworth or Hokio and were taken on little day trips to Lake Alice, and they are convinced they were given ECT. In fact, some actually remember they were given ECT, taken there as a day patient, given ECT as a punishment, taken back to the institutions. There are no records of that. It is not mentioned in their social welfare records, and there is absolutely no record of that from Lake Alice either. So those claims have never been accepted, but we've heard it often enough to know that that is credible. So as discussion about the potential legal remedies for these harms became more known, the number of claims started to grow. Again, I was responsible in taking one of the first claims to trial in 2007, so it was Eastern Attorney General, and at the same time, a former client of the firm, her case was argued, sorry, not way before 2007, it was 1999, sorry. So another client of the firm, former client of the firm, her case went to trial also in 2009 to 2000. So both of these cases were foster care placements, and we were arguing for the first time that the state was liable for the abuse that happened at the hands of the foster parents on the basis that they had placed the children there and they were effectively their agents. So this was very novel, hadn't been argued in New Zealand at that stage, and the case law even in the United Kingdom was still very much in its development stage. So we were arguing new stuff here. So we won at High Court level. The High Court accepted in both cases that the Crown was liable. In the W case, the Crown also accepted that the social worker had been negligent, because in that case the wee girl had tried to report that she was being sexually abused and the social worker had ignored it. And because she was a senior social worker, the court accepted that the state was liable for that. Both claims were lost because New Zealand has an ACC bar. So ACC covers all compensatory damages claims in New Zealand, so both in both cases, both clients were told at High Court level, you've won, but you've got no money. So both we and the Crown appealed. The Crown appealed on lots of things, the Limitation Act, because we won under the Limitation Act as well. So they appealed, we won in the Court of Appeal, so the Limitation Act findings were upheld, and the Court of Appeal also in both cases found that both clients who had been abused before our ACC legislation came into force were entitled to compensatory damages. That all had to be done separately, and private settlements were subsequently negotiated. So, and both of those clients, I have to say, got substantial compensation, which we can probably now disclose, but they again probably establish a high watermark because the compensation in those two cases was substantially higher than anyone else we've ever been able to negotiate since. So following the media, we also had a lot of media interest in this work as well, and so following those cases and the media work, that client group grew really rapidly. So that grew from 50 to 200 to 600 to 800 very rapidly. I think one of the things that was distressing to us was, as this happened, the climate in the courts grew a lot harder. And I think we would say that the judiciary either could not or did not want to deal with the implications of these claims. We tried again to negotiate with the Crown for an out-of-court process, and we thought we were actually getting somewhere with Crown law. We were provided a whole lot of information on a good faith basis. We didn't file claims, but then as we had come to experience, Crown law said, no, we're not going to do an out-of-court process. So again, we ended up having to file hundreds of claims to preserve our clients' legal positions. In 2006, we did a 175-page paper for the Ministry of Social Development and Crown Law. So at that stage, it was a detailed breakdown of placement by placement, setting out allegations made by our clients against staff members and the various experiences they had. So we talked about the cultures, and that covered even things like being, given cigarettes and tattoos and things like that. We gave that to the Ministry of Social Development in good faith. They then passed it on to the police without our knowledge or consent, and then we had a long conversation with the police about whether we were going to hand over our clients' identities and information so that the police could then embark on prosecutions, again without knowledge or consent. And that has become another conversation which I talk about later in the course of the last year or so, hopefully put at an end by a Court of Appeal decision delivered about 2 months ago, or a month ago. But anyway, MSD took the position that it was entitled to breach our clients' privacy, to provide information to the police, whether or not the police intended to act on it, and as I say, regardless of whether or not our clients consented. And our clients had valid reasons for not consenting to that. So we then had to, as I've said, start filing proceedings against MSD. We couldn't manage this huge amount of litigation in the normal way, so it was agreed between Cooper Legal and MSD that we have a judge allocated to manage our claims. We devised a protocol which is still in place today, in which some claims are actively tracked towards trial, but the vast majority sit once we've filed them, so that we can try and settle the claims out of court. Over the years, the protocol has expanded. It now covers Ministry of Education claims. It also covers claims that we now always file for younger clients to protect their legal position. If we can protect their legal position, we will do that. 2007, as I've said, was an auspicious year for the firm. start of a bad time, I have to say. We had the first major social welfare trial about institutions, and that was the White trial. The two plaintiffs were brothers. Paul and Earl were their names for the purposes of the public decision. The trial was in two parts. The first part was about their home life, what social welfare knew about their home life and their liability for failing to act in terms of notifications of abuse at home. And then the second part was about their care and residential care. Both were in Ipuni in the 70s, and Earl was also in Hokio. As we've already said, the court upheld earlier, and it had to really because it was Privy Council decision saying that once a child comes to notice, there is a duty of care that arises. And we just emphasise this because it is an important part of state care that's often overlooked. And it's really, really significant, I think, now. That's what we're finding with state care now. So that there were a number of findings. So,
Mr. Mann and Ms. Cooper, footnote number 29 makes a certain reference to the plaintiffs.
So I've just used the public names for them. That's not their real names.
Oh, good. Okay.
Yes.
Well, I'm just worried about whether the Royal Commission should make a Section 15 order, but we don't need to.
No, those are the public names. So yeah, their real names are different, and White is not their name either.
Okay. Thank you.
So just in terms of the findings, there were some really significant findings about Ipuni, for example, so and Hokio. So the court specifically held that many of the witnesses, and these were our witnesses, 11 in relation to Ipuni and 14 in relation to Hokio, hadn't known one another at all or seen one another, hadn't seen one another for years. But they said, Justice Miller, who was the trial judge, found the evidence compelling. Even though the Crown vigorously cross-examined them on whether they'd got together or whether they'd concocted their evidence, whether they'd talked about their evidence with other witnesses. And I have to say, we still see that issue today, that there is still the view that the starting position, I think, that the Ministry of Social Development, or all of the government agencies start from is that clients are liars rather than accepting that they're... So it's more that burden is put on them of proving their story rather than starting from a position of we accept that you are telling the truth. So there is a starting position of disbelief. In relation to Ipuni, the court held that most boys had been admitted there, were held insecure for 3 days, 23 hours a day apart from showering in this period of PT that Amanda's talked about. Almost all had got the blanketing, the initiation beating on arrival. All talked about the hierarchy and the kingpin. Several talked about the staff using the kingpins to keep order. It was noted that one of the staff members, Mr. Moncrief Wright, who one of the witnesses has already spoken about, had been convicted of several offences against children in 1972. And another staff member, Mr. Tajud, was dismissed in the face of allegations he handled the boys roughly. And as I say, the court overwhelmingly accepted the evidence of the witnesses, our witnesses. So there were findings made that the housemasters were aware of the initiations, that they turned a blind eye to the kingpins, and that a number of staff members were violent towards our plaintiffs and other clients. Hokio, the trial judge found that Earl had been sexually assaulted by the cook, who we've referred to before, who was notorious among the boys. Also found that a number of the staff members were unreliable, that they'd assaulted the boys, that kingpins again were a feature, that Pākehā boys had a harder time of it at Hokio because they were definitely in the minority, and that staff members encouraged the use of violence. So these were important findings, but we lost on the Limitation Act. So the court found that the claims were barred, and even though these clients both had quite significant psychological and psychiatric diagnoses, courts found that they should have been able to bring their claims earlier. And I mean, one of the things I think it's really valid to question is, were they different from the two plaintiffs who'd succeeded only a few years earlier, from W and S? No. And in fact, probably, at least with respect to S, they were less highly functioning. But by that stage, our view is that the court was faced with literally hundreds of claims potentially coming through the system. And that wasn't the case when we'd started out with this work in the late 1990s. There were just a handful of cases. So it's, you know, that timing is interesting. And the fact that the Wellington High Court particularly knew we had already filed literally hundreds of claims. So what happened was that the courts started to really modify the applicable legal tests for the Limitation Act, and what we saw is it got harder and harder for claimants to even get through the Limitation Act. And so lots of claims were being struck out, and we'll talk about that a bit more because the Crown used that as a weapon. And I think one of the things that it's really important to point out here is that it's a choice. It's a choice for a defendant about whether they rely on the Limitation Act. They do not have to. And at that stage, the Crown had an obligation to be a model litigant. In other words, not take technical defences, not take advantage of impecunious plaintiffs. Both the Crown and the churches during this period, and still, rely on the Limitation Act as a weapon to bar what we say are completely legitimate claims. There is no doubt in my mind, well, we know that in the psychiatric hospital claim, the client would have got damages because the judge said so. The judge said, but for the Limitation Act. And in this case, you know, to lose on the Limitation Act was really hard. We'll talk a bit more because this sparked a really negative response from Legal Aid, who on the 17th of January the next year, 2008, told us to stop work and then implemented a withdrawal of aid process, and we'll talk a bit more about that, for 800 legally aided clients. And they would not fund us to appeal the White decision, so we did it without any funding. We appealed the White decision to the Court of Appeal, and again, although we had good findings in terms of the legal and factual findings, they upheld the findings in relation to the Limitation Act, even though they said the judge had made errors, and upheld the other legal findings. And we applied for leave to appeal to the Supreme Court and didn't get leave. So yeah, so we weren't able to take that any further.
I just want to touch briefly on some of the legal barriers excuse me, faced by claims, and Sonia's touched on a couple of these briefly. And two, I want to spend a bit more time on the effect of the ACC, accident compensation legislation, and the withdrawal of legal aid. Now, for those who aren't too familiar with the accident compensation legislation, the whole idea behind it, of course, was that it would replace personal injury litigation, the sort of United States style suing people for harm. And the model was intended to be that ACC would provide you with what litigation would provide you. And that was quite an idealistic situation, I think. And so the accident compensation legislation says that you are not entitled to receive compensatory damages. You cannot sue for those. for personal injury, and the ACC legislation has changed so many times since its inception that working out whether it applies and the extent of cover really is an exercise in and of itself. And that legislation has been altered in response to historic abuse litigation as well. So where the law stands now is that claims for general or compensatory damages for physical abuse can only be brought if that abuse occurred before 1 April 1974. And in the case of sexual abuse, such claims can generally only be brought if the abuse occurred before 1 April 1974 and the claimant had not had treatment for the mental injury arising from that abuse by a certain date. So it's all rather complicated, it's fair to say. There are things that sit outside the ACC legislation, psychological abuse without a physical element attached, and false imprisonment.
And this, of course, is one of the topics we'll come back to.
Yes.
In more detail in March.
Yes, and I guess the last thing I wanted to say is that when ACC does provide cover, we would say that that cover is insufficient. It's something for Parliament perhaps to deal with, but something for the Royal Commission to think about. That if you are a victim of sexual abuse, you're entitled to counselling, not necessarily any financial compensation, and people who experience a lifetime of physical and psychological abuse don't get any counselling under ACC. So it's something that we need to think about, that if you are going to have a scheme that is designed to replace this sort of litigation, then that scheme needs to operate properly. I wanted to Sonia's touched briefly on legal aid. Of course, the effect of the decisions in the High Court was for legal aid to stop work, or say to us to stop work, except for work that was urgent or court timetabled. And in April 2008, legal aid commenced the formal withdrawal of legal aid to about 800 survivors. And we were forced to provide submissions to legal aid for each and every client about whether they could get through the Limitation Act or not effectively, showing what's called prospects of success. And we were only allowed to do that work for them. And so we did that for 800 people, and we went through a review process and an appeal process to what was then known as the Legal Aid Review Panel, or LARP. And there were more appeals to the High Court, brought by legal aid and subsequently our clients as well. And through all of that, we were expected to do the bare minimum of work on the individual claims. It was a massive block on being able to do substantive work to progress the civil claims.
So I'm going to talk a bit more about that. I have to say it was an incredibly difficult time for the firm. Not surprisingly, our clients were distressed at the thought that their funding would be removed and so their claims might have to come to an end. We had to try as best as possible to reassure clients that we were continuing to do all that we could to protect each client's legal aid, but we also had to say to them there were limits on the work that we could do, because we at that stage had little to no funding, and certainly no funding to progress substantive claims. In the face of that, we continued to file as many people's claims as we could, whether or not we had funding, and we continued to do what we could to protect people's legal positions, given that the Crown was using the Limitation Act as a very big weapon. There were financial consequences for me as the principal of the firm. I couldn't guarantee ongoing employment to our staff, and so we lost half of the legal staff over the next few months, which was a relief in some ways because it meant I didn't have to make people redundant, which I was very much dreading. We also had to lose an office assistant position, and we had 4 years, really, I think, of considerable financial uncertainty, as well as other pressures being brought to bear on us, which I think are more properly the place of the redress hearing. During this time, we did a huge amount of work, and we have estimated it, nearly $1 million worth of work without any funding. And we did this to protect our clients' positions, as I've said. We continued to file claims, we continued to do as much work as we could to protect our clients. And as I've said, one of those things was taking the white claims through to the Court of Appeal and the Supreme Court without any funding at all. Matters were made more difficult for us during this period because Crown Law, particularly acting for the Ministry of Social Development, in the full knowledge that we were going through legal aid funding difficulties, chose to insist that some cases go ahead in terms of testing the Limitation Act. So these were effectively strikeout applications, and they also insisted on some trials going ahead. That wasn't just the Ministry of Social Development, there were other ministries we were dealing with as well. But on at least 2 occasions, the Ministry of Social Development, through Crown Law, pushed for a limitation hearing on particular claims when legal aid had been withdrawn before the hearing. On the first time that happened, thankfully, the judge allowed the case to be adjourned because when the case was originally supposed to have gone ahead, we were ready to go and the Crown wasn't because it didn't have an expert witness brief ready. And so the court agreed, because we'd been ready to go ahead on the first hearing and we'd had legal aid at that stage, it would be unfair to force us to go ahead. But on the second occasion, the court knew that we were waiting for a decision from the Legal Aid Review Panel about whether funding was to be reinstated. The Crown, so MSD, and I think the Salvation Army was also involved in that case as well, pushed the hearing on, knowing that legal aid was withdrawn and that we were waiting for a decision, and the court said, too bad, Cooper Legal, you've got to go ahead with that hearing, and not only that, we are not allowing you to withdraw either. So I have to say that was an extremely difficult position for our firm to be put in. The client wasn't expecting us to go ahead without any funding. And while we could have done a few limitation hearings without funding, we had 800 clients, pretty much all of whom were legally aided. And for each of these clients, we needed to obtain expert reports from a psychiatrist or a psychologist to address why they couldn't take their claims earlier. These reports cost upwards of $10,000. It just wasn't feasible for us to do that. What happened with that second case is ultimately legal aid was reinstated by the Legal Aid Review Panel a few days before the hearing, so we were able to be there. But by that stage the client had suffered a massive disadvantage. We hadn't been able to prepare properly, we hadn't been able to get reply evidence, and not surprisingly the outcome was not good for that client. And I think the reason why we've given these examples is these just show the inequality of arms that our clients face. And one of the things I noticed during that period of time, it would have been an easier option for me and the firm to have just walked away from this work. And there was a lot of discussion from other people saying, perhaps that's what you should do. Because we had to make some really unpalatable decisions. We had to reduce work, we had to deal with the distress of our clients. But ultimately, I didn't want to be yet another person who let these people down. I didn't want to be another person who decided this was too hard. And so we kept going. I think it's important to say that our relationship with legal aid now is a very positive one. And we are really grateful for the ongoing support of legal aid, and we are constantly mindful that we use public funds, so we try to do so wisely. And one of the things that we do is every time we settle a claim against the state, there are arrangements in place so that legal aid receives a substantial contribution to the costs. So our work is reimbursed back to, largely reimbursed back to legal aid. I also want to talk about the Crown litigation strategy, because that also changed during this critical period. So prior to 2012, Crown Law and the government agencies were supposed to act as model litigants, as I've said. And so they're supposed to avoid, prevent and limit the scope of legal proceedings wherever possible, not contest liability if the real dispute's about quantum, not take advantage of a client who doesn't have money, and not rely on technical defences, unless the Crown's interests would be prejudiced by the failure to comply with a particular requirement. What was really interesting is that without any substantial public consultation in 2012, the Cabinet directions for the conduct of Crown legal business removed the model litigant obligation and replaced it with an obligation to act in a manner which satisfies the Crown's objectives. So I think this legitimated what we'd already seen as the response to our claims. So what that meant, and I think really we've continued to see that up until the Royal Commission, which is producing some positive effects for us in Crown litigation. But what we've seen is it meant the Crown pursued vigorously setting down hearings, and for a long time, in the knowledge we had no funding, the Crown asked for punitive directions and orders if we weren't able to comply, and it continued to raise the Limitation Act as a barrier to the claims, even for clients whose claims were filed technically within the time frame, but where leave had to be given, and that was even within the last few years. And this was supported by the courts.
Ms Hill, the next topic is CLAS, the Confidential Listening and Assistance Service. Because we had Judge Henwood here last week, you may be able to just summarise some of the key points under this heading.
Yes, and I won't go into that except to acknowledge Judge Henwood and her comments and the extraordinary work her team did. And just to pick up on one comment, and during her evidence she read out her personal note from the final report of CLAS, and she wrote that a picture was painted of a careless and neglectful system. And I wanted to emphasise that because defendants often fall into what I call bad apple syndrome. There's one or two bad apples or a few unfortunate people, and our position has always been that the system itself is broken. And so for Judge Henwood to say that back then, I think was courageous, but it's also correct. And that's all I need to touch on in terms of CLAS.
And in a similar light, our next heading is the human rights perspective. And we are scheduled to have Rosalind Noonan here a little later in the week. So again, you may be able to summarise your key points.
I can. In short, from about 2012, we started to change the conversation, and we started to shift from a torts focus to a human rights focus, both in terms of our domestic legislation and the international covenants that New Zealand had signed up to. And here we acknowledge the advice and support of our colleague Dr. Tony Ellis, who has been invaluable over the years. And we've talked about so many of the things today that meet the definition of torture and cruel and unusual punishment or treatment. And New Zealand ratified the United Nations Convention Against Torture in 1989. And that Convention provides that states have to provide a remedy when acts of torture are found. And in our New Zealand legislation, the UNCAT, as it's called, is found in the Crimes of Torture Act 1989. And it's important to know a couple of things about this. New Zealand has entered a reservation to UNCAT that says that compensation will be paid only at the discretion of the Attorney General. And then in the Crimes of Torture Act, it's a requirement that the Attorney General consent to any prosecution under the Crimes of Torture Act. And the defendant in these civil claims is the Attorney General. So in short, it's the government's lawyer who decides what torture is, who should be prosecuted for it, and who should be compensated for it. And that, to us, is really problematic. And in our written brief, I've talked about the number of shadow reports we've made to different United Nations committees over the years. And we've continuously tried to bring an international spotlight onto the experiences of survivors in care. And we think that slowly the snowball effect of adverse comments, because there have been ongoing adverse comments from the United Nations, has started a very slow turn towards the Crown agreeing to come to a better position and a less confrontational position. But it has been very slow. But we did start to see that turn there.
Our next heading, Ms Cooper, is the Bill of Rights Act 1990, which I take it provided another avenue of claim against the Crown.
Yes, that's right. And I think we referred to that right at the beginning. We've always said that people who were in care after the 25th of September 1990 have additional claims for breaches of their rights under the New Zealand Bill of Rights Act. And some of these include the right not to be subjected to unreasonable search or seizure. So we're looking at a number of programs. Whakapakari was one where children were strip searched without any authority. The right to be free from arbitrary detention. So, being detained on an island like Alcatraz, for example, being locked in timeout in inadequate and inhumane circumstances, in seclusion rooms without legal authority. The right, and an important one, is the right for anyone who's detained to be treated with humanity and with respect for the inherent dignity of the person, and the right, obviously the critical right, not to be subjected to torture or to cruel, degrading or disproportionately severe treatment or punishment. We've never actually got a trial yet to court because they've settled. We've been trying, I think, for about the last 10 years to get one of these trials actually to court because there are really lots of questions. So, for example, a child who's in the custody of SIFs now or who was in a psychiatric hospital, we would argue that they're clearly detained for the purposes of the Bill of Rights Act, but that needs to be tested. And we say too that the use of third-party providers doesn't change the Crown's obligations under the Bill of Rights Act or lessen its liability for what happened in the care of third-party providers, but that all needs to be tested. We don't know yet what the courts will make of our clients who suffered sexual abuse or physical abuse, because at present the only cases that have been dealt with have been adults in prisons and police cells. So we don't know yet what the courts will make of children being sexually abused and physically abused and, locked up in inhumane circumstances. We don't know. We've got 3 plaintiffs who are currently on a trial track. And their claims are at this stage scheduled to be heard in a very long trial starting in August next year, assuming they don't settle.
Now, the next section from page 38 deals with the various different settlement processes. And
Yeah.
again, this is obviously a topic that we will come back to next year in the Royal Commission. I realise it's almost impossible for you to summarise all of the complexity of this work, but if you're able to highlight for the Commissioners the key points of the next section, I'm sure they will appreciate that.
Okay. One of our big bugbears, and it's been a theme throughout the time of working in this area, has been access to information and records. This, as I say, it's an extremely vexed issue. Claimants are entitled to receive a copy of their records under the Privacy Act, but the issue with that is that those records are routinely heavily redacted, and so they are difficult to make sense of, and also too, they only contain the client's personal information or their family information. So there is a lot of important information held on other records, institutional records, like the secure register or the punishment register or the day books or the timeout register or the seclusion register. And a client accessing their own records will not get that information at all. Redactions is a major issue because it's used as a means of denying what happened. I can give you a crazy example of redactions that we've seen. I mean, for several years, the Ministry of Social Development refused to give us any court documents because it decided that the family court rules applied, which has some quite strict rules around access to family court documents, that decided that applied to all court documents. And we had an ongoing battle with MSD saying it doesn't apply to all court documents, it only applies to specified family court documents. They've only just started to give us the other court documents this year. So we've had 4 or 5 years where those records were not provided to us at all, completely redacted. So they're now having to redo 4 or 5 years worth of disclosure to provide us with those records now. And they contain absolutely vital information. They often help you to piece together where a client was, why they were placed in care, what was happening with their family, what the state knew about their family. It's absolutely vital information to understand where, why, what. And as I say, we had about 4 years where we didn't get any of that information. Well, we couldn't explain reasons why we could. Just crazy things like we had one client, and this is just an example, where the word abuse was the first 2 letters of that word were redacted, so it was use, all the way through the records. So the letters A, B were redacted every time the word abuse, and that was so we couldn't, of course you could figure it out, but that was to protect the privacy of the parents who were abusing the children. So it's these kind of, often though that information will be completely blacked out on the basis that that's to protect the third party. And so this just creates enormous obstacles to being able to, one, work out what the state knew, which is relevant to its obligations, but also to put the client's claim together. And that is an ongoing issue to this day. And in fact, we would say that has got worse. We had a period where MSD accepted that it should be open with us, and we had an agreement about what categories of documents we would receive. Then I think lawyers stepped in at MSD and said, no, we should not get all that information. The Privacy Act applies, Official Information Act, so we just stopped getting a whole lot of information that we'd previously been entitled to. And we could see, like, you know, we act for siblings. So we'd get one sibling's records where some information would be disclosed, and then we'd get the other sibling's records where other information would be disclosed. So you would be able to see that information about sibling A had been redacted from sibling A's records. So it was about sibling A, but redacted, but it would be in sibling B's records. So we'd know they'd redacted it improperly. And so we decided to take that to the High Court, and that's one of the advantages of being lawyers. We have a lot of the claims filed in court. We can ask the High Court to look at this and make orders that fix it. Claimants on their own can't. So we said to the High Court, look at these examples. Here are records where we've got this page that's been redacted, and here's the siblings' records which show that this was actually about this sibling. Hasn't been redacted in the siblings' record. So the High Court then made a ruling that we get two versions of the records. So we get a Privacy Act version of the records, which the claimant is allowed to see, the client's allowed to see, and we get an unredacted version of the records. So we get the complete unedited version of the records. And that makes our jobs so much easier, but claimants still have all this blacking out. And for the many clients now, because we don't file all claims, we don't have the capacity to do that, we still get the same versions as the claimants, the survivors, with these multiple redactions that make it impossible to piece together what happened, why it happened, when it happened, and most importantly, what the state knew and did or did not do about what it knew.
Ms Cooper, I think that's a good moment just to pause, and I'm noticing the time, Mr Chair, and I'm wondering, in light of all of the important evidence we're hearing today, whether a slightly shorter lunchtime might be helpful.
Okay.
Would you like to nominate a time?
Could we get away with 45 minutes? Thank you, Mr Chair.
Mr Mount.
Thank you, Mr Chair. Ms Hill, I think you are going to begin by talking about, at a high level, in summary form, the process adopted by MSD.
Yes, recognising that we'll have time in March to deal with settlement and redress in quite a lot of detail. So what I'm about to summarise is fairly broad. So settlement processes with MSD have had a large number of iterations. They've changed almost constantly over the years. But there's some things that are consistent. And the first is a lack of consistency. They are not, the assessors are not consistent in how they treat staff members, and what information they look at, whether they look at just the personal file or the broader information, and they're not consistent in terms of the quantum of compensation offered to claimants.
That's the amount of money.
Yes. So when I talk about quantum, I talk about amount. They are also universally lacking in transparency. Nobody ever knows really how claims are assessed, against what standard, or how information is treated. They're not accountable because MSD is investigating its own staff, some of whom are still employed by MSD or Oranga Tamariki. And so MSD has said very clearly it has a duty to its staff members, so it cannot possibly independently investigate claims. And delay, so much delay. So in 2016, it was taking the ministry 4 years to address claims that came to it. And so the fast-track process was introduced. And this is what I would call a quick and dirty approach to a backlog of claims. It was flawed, it was underfunded, and while some people did feel that they had meaningful settlements as a result of it, a large number of people didn't. And after that, people who rejected their fast-track offers got stuck in a mire because the full investigation process was incredibly slow, and it was almost stopped while MSD started a new process, which is the current iteration. So there's about 40 claims which don't appear to be progressing at the expense of more recent claims. And by more recent, I mean claims that were taken to the Ministry in 2015. So we're still looking at a 4-year delay. The current iteration has got the same problems. We've asked for the rules of assessment, and we received a completely redacted copy. We complained to the Ombudsman, we got a slightly less redacted copy, and I believe that's the copy that the Royal Commission has received as well. So nobody knows how claims are assessed, and we have to do educated guesses to advise our clients. What we can say is that the 2 or 3 offers that we have seen under MSD's new process appear to be worse than offers settled previously. We are seeing a steady decline in the way claims are assessed and the amount of compensation offered.
Ms Cooper, I think you're going to pick up with the Ministry of Health and the Ministry of Education.
That's right. So after the chain of litigation all the way up to the Supreme Court for the Ministry of Health claims, well, at that stage the defendant was the Crown Health Financing Agency, we were approached to engage in settlement discussions, and on December 2011 a settlement process was approved, which involved settlement offers being made to 320 claimants then. Offers were made to all of the clients who had made claims at that stage, even those who'd had to discontinue their claims as a result of the Limitation Act hurdles or other Mental Health Act hurdles. So, 320 claims were settled in 2012, and we settled the vast majority of those claims. After that, the Ministry of Health took back the management of the Ministry of Health claims. That was approved by the Minister of Health in 2012. So I've already said they'll consider any claims relating to abuse in psychiatric hospitals. Now they've recently included that to include state hospitals prior to 1993. After 2012, the top payments available to claimants halved. Under the process we negotiated with the settlements in 2012, the highest payment was $18,000, and even that's modest compared with other settlements, as you would have heard. That's now $9,000, and the lowest payment I think is $2,000 or $2,500. So I have to say that the Ministry of Health payments are at the bottom of the rank. So while there are some pluses about that process, pretty low level burden of proof, it doesn't rely necessarily on records, although you have to show somehow that you were in a psychiatric hospital, but that can be even if you've made a claim to ACC and referred to the fact that you were in psychiatric care, because often the records don't exist anymore. That's the reality. It's relatively fast. Typically the claims are resolved within about 6 months. At the outset we had one slow period while the Waitangi Tribunal was potentially going to hear the claims. But there are some flaws. It won't hear claims for those who die. So even if you die, if you've made a claim, we've notified and asked for records, but before that's been considered, too bad. And also too, I think there's actually nothing about the Ministry of Health process in the public space. Like, you cannot look on the Ministry of Health website and find out anything about the Ministry of Health settlement process. As I've said, the cap on quantum is really poor. It's definitely the lowest. It's at the bottom ranking of all of the government state settlements. And given that there is supposed to be parity, that's inexplicable. Just to give an example, we had, to give an example with the disparity with the Lake Alice settlements, we had One client who was a child in the Lake Alice Adolescent Unit, so he was entitled to a payment under that process. And then he was also entitled to a payment because he'd been abused in other hospitals. For the Lake Alice Hospital, he got $81,500. For his other hospital experiences, he got $6,000. And his experiences in psychiatric care were not remarkably different. The only difference was that at Lake Alice, he'd suffered sexual abuse on top of the other abuse he'd suffered, but otherwise his experiences were pretty much identical. And to try to explain to him the reason between one being $6,000 and one being $81,500, impossible.
And the Ministry of Education?
Ministry of Education, what can I say? It's very ad hoc. It's, I think, probably of all the processes, the most flawed. There is, again, absolutely no transparency about how the Ministry of Health assesses claims. They do have an independent assessor who will meet with claimants, but that person has worked within some of the Ministry of Education schools, so there's a question mark about independence there. It takes literally years for any MOE claim to be determined, and the settlement payments that we've had so far have been in a reasonably low range, between $5,000, I think, and $35,000 is the top we've seen so far. So again, at a lower level. We know that the Ministry of Education does not take into account propensity, or what we call similar fact evidence, which courts would take into account. So say, for example, if we're able to say, well, we've got 8 other clients who make the same allegations, the Ministry of Education will completely ignore that, or put that to one side. It does not take that into account at all. So that means it's able to say, unless there is documentary evidence, it will not accept allegations. So I think the burden of proof for people in the Ministry of Education process, I would say for some claimants it's beyond a criminal standard. It's certainly higher than a civil standard. And that's the point. There is no transparency about what standard that it's adopting, so we don't know. That is also beset with major delays, years and years. There is no agreement with the Ministry of Education in respect of the Limitation Act, so at the moment we are forced to file all Ministry of Education claims. We've been promised a one limitation agreement to rule them all. In other words, that will cover all of the government agencies, but so far that has not appeared, and we've been trying to work on one with the Ministry of Education since, I think, at least 2016, and here we are nearly at the end of 2019, nothing yet. So as I say, we have to file. Ministry of Education, very harsh. If there's no documentary evidence, it typically denies things, and as we know, most abuse wasn't recorded. So, as I say, it sets an almost impossible bar.
Ms Hill, still at this high level, the churches.
Touching very briefly on settlement processes with churches, there's a myriad of responses and processes, even within a church that people would see as a whole, like the Catholic Church. There are obviously a range of orders and so different areas of the country. Now, the Catholic Church has the Path to Healing, Te Hohangarongo, but while it's a good process on paper, it's an opt-out process. So a number of Catholic orders opt out of the Path to Healing and instead either defend claims aggressively or opt for another process. We understand there is no common process with the Anglican Church, and that may be being written at the moment. And the St John of God order, Sonia talked about Maryland's, it's really interesting with them. They're an Australian order, and they pay a higher level of compensation for abuse at Marylands, but in their view, it's still far less than they would have to pay if that had occurred in Australia. So there's a myriad of structures and processes, some better than others, and that's a whole other hearing on its own, I suspect.
Speaking of which, we have another topic which would justify a hearing on its own, and that is the interface with Maori.
Yes, and if our technical people could jump to the very last photo, which I think is really poignant and one that I wanted to have today. We've always been aware that Māori were disproportionately affected by the systems and practices of child welfare and its successor agencies since its earliest inception. And there's better people than us to speak about that. But what we can tell you is that over the lifetime of the claims, our clients have been disproportionately Māori. That we see in the individual claims, Māori children were more likely to be uplifted from their homes, were more likely to be separated from their siblings, and more likely to be charged with offences. We saw that Māori tāne, Māori men, were more likely to be placed into institutions rather than foster homes or with whānau. And we see on a distressingly regular basis the either unconscious or blatant racism expressed in records. And we are aware that welfare impact is intergenerational. We act for up to 3 generations of one whānau at any given time. We see their children and we see their grandchildren, and that is a really distressing thing.
You've talked about the various redress processes of the different ministries. Do you know, and again I'm asking this at a very general level, whether in designing those processes any of the ministries have engaged directly with Māori to take into account their particular position?
The only instances we're aware of occurred last year when MSD had some hui with the selected people to talk about how its processes could be improved for Māori, but we've seen no tangible changes or outcomes that have come out of those hui.
Was there a comment you wanted to make about the slide that we saw a moment ago?
I think it just reflects the fact that there's a group of young Māori men on a couch in their pyjamas, and they're all Māori. They're all Māori. And there's only one other thing that I wanted to say here, and it's come up a couple of times, is that in institutional, they're not all Māori, my apologies.
3 out of 4.
3 out of 4. And the Pākehā boys in those homes were often smaller and weaker, and they became targets. So the flip side of a disproportionate response to Māori was that there was a small number of Pākehā kids in some of these institutions. And just in the same way as some of the gangs started in the homes, some of the most well-known white supremacists in our country were those small Pākehā boys.
Ms Cooper, can we turn to the final section of your brief with the heading, Where We Are Today?
Yes. So as we said at the start, we represent about 1,250 people, most of whom are asking for redress from the state or faith-based institutions for harm. Sadly for us, the number is not declining. Some months we receive a new instruction or a new client every day. In fact, one month we had about 1.5 new clients every day. We interview each client face-to-face, and we work as quickly as we can to put together their claim documents, but it's fair to say that because of our workload, we are behind. We are continually hampered by delays and changes to the processes. Talked about the MSD delays and the Ministry of Education in responding to the claims. And so we spend, or our PAs spend a lot of time explaining why this is happening to survivors, and we spend a lot of time following up with MSD and the Ministry of Education to find out what's happening and why nothing has come to us. And look, understandably, our clients, survivors, are distressed, angry and bitter about how long the process is taking, or about how the relevant defendant responds, and we cannot blame them for this. A lot of our clients say they wish they'd never started their claims because of the delays, because they feel that having been made by us in our process, because we do have a rigorous process, being made to dredge up these childhood memories has caused them harm, particularly when it takes such a long time for there to be an outcome, and often that outcome is not a very meaningful acknowledgement, or there is little to no redress provided. I think one of the things that we can say is because of our large client group and because of the long number of years we've been doing this work, we have a huge amount of visibility over the way in which whole families in whānau have been affected and continue to be affected by decades of involvement with social welfare and its successor agencies in particular. And I think one of the things we still see is that generations have all been taken into a care, with the resulting loss of their culture, loss of language, and disconnection. So the role of social workers and social workers is often described as a tool of colonisation by Māori, and we've heard that during the course of this hearing. We certainly agree with that, and we think it'll take several generations to undo this harm. We wanted to talk again, as we flagged at the beginning, about the discretion of the Commission to hear from people who are in care after 1999. And we're pleased about this because, as I said at the beginning, we see so many young people who come to us who are still experiencing abuse in care today. And I was talking to you, Simon, I had to do a special sitting at the District Court less than 2 weeks ago for a young client who is in Oranga Tamariki's custody, and the proposal was that this young person in Oranga Tamariki's custody after court was to be dropped with their suitcase out on the street without a placement. That's less than 2 weeks ago. So I put this before the District Court judge, who obviously said, not on my watch, placed the young person in a motel overnight, and magically by the next day, when we were required to go back to court, a placement had materialised. But if there had not been strong advocacy and if there had not been a strong judge, that young person would be on the streets now, even though they are in Oranga Tamariki's custody. So that's less than 2 weeks ago. One of the challenges we just note, and I just finished that really by saying, is that a lot of the challenges for our younger clients is that their caregivers or those staff members who were in residences are still employed, still contracted, or are still employed by Oranga Tamariki. Our experience of this is that MSD and Oranga Tamariki dealt with this issue extremely poorly. At one point, both or either or agency provided a huge amount of information to the police and to the perpetrators without consent or knowledge of the claimants. The position taken was that there was a duty to provide this information, and that the state agency, Oranga Tamariki and MSD, were protected by this by an exception in the Privacy Act and in the Oranga Tamariki legislation. We took issue with that because we know that our clients have safety concerns, valid safety concerns. So we were only able to protect the clients who had claims in court, and thankfully for all our younger clients, we do file their claims in court. And the High Court said to MSD and Oranga Tamariki, you're not allowed to provide that information to the police unless you've made an application and the client either consents or the court approves it. Oranga Tamariki and MSD appealed that to the Court of Appeal. We're happy with that decision. wanted to be able to still pass on information to police and perpetrators. And so that was heard in April this year. We got the decision a few weeks ago, and thankfully the Court of Appeal has upheld the High Court. So, as at today, MSD and or Oranga Tamariki still need to apply to the court, and the court still has supervision over what information can be provided to the police and to perpetrators. But I note, again, that only applies to clients whose claims are filed in the court. And for the vast majority of people, their claims will not be filed in any court. We've taken steps and continue to take steps to protect our clients. And I just wanted to say that we do this work as lawyers. We have limited tools to try and bring about some sort of truth and reconciliation process because we think it's important to try and break the cycle of harm in New Zealand. The civil claims are only one part of the challenge. We are really clear that there needs to be a hearing and a reckoning with the truth of this history of Aotearoa, and a commitment both to healing the past, which unfortunately is still the present, and changing our future. And that's going to take far more than legal action. And we really support the work of the Royal Commission in unveiling that truth and helping us to move forward in a way that will protect those tamariki young people who are now and in the future will come into the system.
Thank you very much, Ms. Cooper, Ms. Hill. There are dozens, if not hundreds, of questions that I'm sure we all have, and we're not going to ask all of those now. But as you know, the Royal Commission is coming back in just a few months' time to look in detail at redress as a topic. In the couple of minutes that we've got now, do you have a headline in terms of what the ideal redress world would look like, or is it best to hold that off for next year?
Our big request is that there be an independent process. I think it may be all right for preliminary processes to be dealt with by the individual agencies, but there needs to be an independent process to go to when the claims are stuck, or where there is a difference about the law or a difference about the facts. And we're really clear about that. We've always been really clear about that. I was at a meeting at the Human Rights Commission, I think it was last year, and the way that the current processes work, I think was Justice Rong Young described it as, at the moment, the government agencies and the faith-based institutions as the abusers put themselves in the place of the saviours because they get to make the apologies and pay the compensation. And there is something just morally bankrupt about that. There needs to be independence, and I think that will provide some more integrity and transparency about the processes.
Ms. Hill, do you have anything to add?
I would add accountability and transparency, that everyone knows what the rules are, the guidelines are, and that they're the same across particularly the state agencies. Because if you don't know how a claim is being assessed, you are immediately at a disadvantage.
Thank you very much. Mr. Chair, some of our colleagues have indicated that they may have some questions, but I must say there is a general mood that there is so much detail and so much important material to cover that I think in many cases people will elect to come back at the next hearing.
Yes, I know that is certainly a feeling that's shared by some of my colleagues on the Commission as well. But there is a right to ask questions, and this will be the time to air those, even if in a preliminary fashion.
Yes, a right with permission, of course.
Can I then place the matter in the hands of Council to exercise at this point, should they wish, a right to address questions to Ms Cooper and to Ms Hill, and it may be helpful to the witnesses if it is confirmed in an early question for whom which council acts. Ms Aldred, can I start with you? Thank you. Ms Sykes, can I ask you next?
Can I just make a statement rather than a question?
We'll just find you a microphone, Ms Sykes. Would you like to come up to...
Here we are, Madam
Oh,
Registrar.
no, the microphone is
obliging.
coming. Here we go.
Kia ora kōrua, ngā wahine mārei kura e whawhai mō tēnei o ngā tiro ātāhua, he kaupapa ātāhua aha koa he uaua. I'm here today with my friend Miss Davis, who were assisted by your affidavit in the Waitangi Tribunal, and we can't express our gratitude enough. I'm also here in a capacity representing a number of survivors who I referred to you over the last 20 years, and they wish to convey their respect to you for listening when others didn't. We have questions, but in the interests of perhaps making a more opportune time for those, so I just wanted to convey those two matters personally to you. We will be asking questions in March. One issue that we would like explored is that the Ministry of Māori Affairs seems to be absent in your discussion, and those matters certainly arise for the 1950s and 1960s and 70s, so those will be the matters we may ask questions on in March. So thank you. Kia ora.
Kia ora.
Thank you, Ms Sykes. Ms McCartney.
Thank you very much. Please, the commissioners, and good afternoon.
You'll need to press the...
Thank you. My name is Jan McCartney. I haven't met with you before. I am acting in this Royal Commission together with Ms Lawton for the National Collective of Independent Women's Refuges. And you will have seen from the terms of reference that one of the terms, and this is what I'm asking you questions about, just for context at the moment, is the impact on whānau, iwi, hapu, and communities. And in that regard, and in asking these questions, can I say that we and Women's Refuge acknowledge the work that you've done, the obstacles that were put in your way, and the results that you have achieved, which, from what I have heard, have been frankly remarkable, given all that has happened. Can I, again, just in terms of context, ask a number of questions? The first is this. Judge Henwood listened to 1,103 abuse survivors. And in her report, and this, members of the Commission, is at pages or paragraphs 107 and 108, she spoke about or recorded what happened when her report was received by the government of the time. And the response, which was that of those in care, only 3.5% had been the subject of abuse. Her evidence is that that percentage was drawn from the number of people who made claims, and that it seemed, according to the response, that for others in care, their response was positive, or maybe neutral? And this is my first question. From all the work that you have done, have you acted for or interviewed anyone who described their response as positive? Ms. Cooper?
No. Having said that, people have had some parts of their care that they've experienced positively. So as we said, people have been in foster placements that they've loved, but then have been removed from them. They were in family homes that they loved and were removed. They had a safe and happy time with their own families before they were removed. But the purpose for coming to us is because they have suffered abuse in care. So we are not expecting to hear the happy stories. We are expecting to hear about the harm that people have suffered. And I want to support Judge Henwood on that 3.5%. When that report was written, I mean, it was at least, I would have thought, 12 years ago now, so it was a report that MSD commissioned. We got to see a copy of it, and it was based on the numbers who had then come forward to the Ministry of Social Development, and at that stage the numbers were quite low. I mean, the numbers have drastically multiplied since then. So I would have thought that that figure is already quite wrong. I would have thought it's at least doubled potentially.
I'd certainly agree with that. And another thing that Judge Henwood said was that there's no evidence to support the number of people who have had positive experiences in care. The 3.5 really is a number that doesn't have a lot of evidence to it, and there's not a lot of base to it. And I have to say the expression only 3.5 is really difficult for me, because that's still too many.
May I ask, going forward from that answer, have you seen any evidential basis for a figure of persons abused in state care?
Only that one that I've just referred to, and as I say, that was based solely on the number of claims that had been made to the Ministry of Social Development at that point in time. And of course it only covered the Ministry of Social Development too. It didn't cover the Ministry of Education, it didn't cover the Ministry of Health, it didn't cover corrections, it didn't cover health camps. So there were a whole lot of people that were excluded from those figures anyway. And it's very time dated now.
You have referred to documents that have been withheld from you in the course of your work. Would, for example, the timeout register and the secure register, would that assist in identifying the extent of the abuse?
Absolutely. I mean, we know that from the trial work that we do. We refer extensively to the secure registers and the day books. I mean, because to be blunt, a lot of that even that documentation has been lost. You know, there've been fires and floods, and I mean, one of the reporters found a whole stream of stuff in an old, you know, just kind of floating around the premises of Hokio or Kohitiri. So, and of course, I do note that with the Ministry of Social Development, just as my firm was starting to embark on the work in the mid-1990s, MSD ordered the destruction of a whole lot of staff files in 1999. Timing? Interesting. But we know from the trial work that we do, where we are required to be given that material, they're extremely helpful. The day books are probably even more valuable, because the day books are telling you kind of hour by hour what's happening. And so there will be restraints, and there will be times in time out and seclusion that will be noted in the day books, but are not noted on any seclusion register or any other document that they should be noted on. So we, you know, when we get to trial, we get this massive information, that we have to put together for an individual client to piece together, because we also get incident reports. We get the whole raft of documentation about that client and about the institution generally that will enable us to put together their story. But an individual claimant going to the Ministry of Social Development will only get their personal file. And so you will not be able to work that through. And as I said, a lot of records are missing from personal files. I have to say, we've been dealing with a number of claims recently where clients have told us they've been in multiple placements. We've got records for maybe 2. So where have all those records gone? And EBSD and the Ministry of Education won't accept a claim if there aren't records. So what do you do with that?
In relation to your evidence about the initiation beatings in the state care residences, would that indicate that persons going into those residences, up to 100% of them, would be subject to abuse?
Yeah, definitely. I think it would be like we knew there. I can think of a couple of, and it happened, for example, in the White trial, when Earl went to Hokio, for example. He was lucky he went there in the school holidays, so none of the kids were there, so he missed out on his initiation beating. So, we've done hundreds and hundreds of claims for children who've been through the various residences, and that includes the girls as well. It goes without saying almost. As I say, you were just lucky if you missed an initiation beating.
Can I ask you to refer to paragraph 267 of your evidence, where you refer there to an enormous number of your Maori male clients being in prison?
Yes.
Again, this is just context. Do the offences for which your male clients are in prison include offences of violence? Are you able to say this?
For some,
Yeah.
yes. But, again, I have to say for us, what they're in prison for is not important to us. We accept all our clients for who they are.
No,
So as I say, we actually don't collect their criminal conviction histories. We don't ask them about their criminal histories, because for us, it's not an important factor of our work. What we are interested in is how their time in care has impacted on them. So if violence has been an impact, we are definitely interested in that, and we reflect that in the claim documents that we put together, and there is certainly a very, very clear link.
Thank you. And when you refer in your brief of evidence, right at the end of it, paragraphs 277 and 278, to the cycle of harm, and breaking the cycle of harm, that would include, wouldn't it, breaking the cycle of violence that we've just referred to?
I think it's impossible to divorce what we know about state care from our statistics around family violence and domestic violence and sexual violence. And while we can't say that every person in care has been violent, we can't draw that conclusion. What we know is that so many of our clients are angry, and so many of them grew up in a culture of violence that has been perpetuated. So there is certainly there is a correlation there. And when you think that about, I think it's 82 or 87% of our prison population have had some contact with welfare in their lives, then you can certainly start to see a pattern.
Now, just talk about compensation that is paid, and your evidence, which I acknowledge, that not one of your clients, in your view, has received adequate compensation. Would it be fair, or is it your experience, that higher compensation payments generally result in bringing about more positive outcomes for your clients?
Again, it is a difficult question for us to answer because, of course, once we settle a claim, our work for a client finishes, so we often don't know how they've used their money, to be honest, what they've done with it. I think what we can say is, anecdotally, we know that clients have used their compensation to set up businesses, which is a huge advance from where they have been. We know that a lot of our clients use their compensation to actually make better lives for their own children or their own grandchildren, mokopuna, because they recognise that they've probably caused harm to the next generation or generations and they want to make it right. So I think that's something we can say, but for us, compensation is about vindication. It's about an acknowledgement that we've caused harm and that we're going to put that right in some ways. New Zealand compensation is really poor compared with our Commonwealth counterparts, and that's largely because of ACC, as we've explained. But I think, we have seen it actually making quite a meaningful difference to people. We also know that the apologies can make a big, meaningful difference to people. I mean, we know that people will frame their apologies and put them on the wall. And I think, too, acknowledgement of harm, it's taken into account in sentencing. So for a prison inmate or somebody who's facing the criminal courts for sentencing, we are regularly writing letters to support, to say they've made a claim or they are making a claim for abuse they've suffered in care because it's relevant in sentencing. So there are multiple ways in which acknowledgement of that abuse, I think, empowers and enriches survivors' lives.
Coming to the issue of costs, legal costs that were paid to you for the work that you did, did you ever have access to the quantum, the amount of costs that were being paid to Crown Counsel?
Yes. With the trials, costs became quite a vexed issue, I have to say. So we were regularly doing Official Information Act requests to the Crown during the trial processes as to what Crown Law was being paid for work that we were being paid for at legal aid rates, which for those of you who do legal aid work will know they're considerably less than commercial rates, about a quarter. We know that the White trial is an example. I think our costs were something like 300,000 or 400,000, and we were acting for two plaintiffs. The Crown's costs in that were over 900,000.
Yes. Sorry.
We know that in the whakapakari trials that we did, and another trial that we did, the Crown's costs were around about $3 or $4 million, and they settled for a pittance. And I guess our cynical view was when we thought about how many clients' claims could have been settled without the dreadful litigation process that we and our clients were subjected to over quite a number of years.
And directing those funds instead to the settlement process.
Yeah.
This is my last area of question. It's about the Limitation Act.
Yes.
You will know that there have been some movements in the way in which the courts address limitation in particular where there's a fiduciary relationship, fiduciary duty. I'll just expand on that. Some overseas jurisdictions are dealing with the fiduciary duty relationship as an exception to limitation. Do you know, because I don't, I'm asking you this question, whether that argument has been developed in the New Zealand courts where children have been wards of the state?
So in our earlier cases, and in fact we still plead in fiduciary cause of action. In New Zealand, the way that fiduciary relationships are interpreted under the Limitation Act is if they're pleaded alongside a tort cause of action, the equitable cause of action, the equitable limitation period is interpreted in the same way as a tort limitation period. So it means that the Limitation Act, the normal rules apply, so you don't get any special treatment. I think the other thing that I should say is that fiduciary causes of action have been really difficult in New Zealand and Australia and England. I don't even know if they've pursued them, to be honest, because although you may be able to establish that there was a fiduciary relationship and that there was a duty, to prove breach has been really difficult. When I argued S and Attorney General in the Court of Appeal back in 2002, I argued quite strongly that there had been a breach of a fiduciary relationship because in that case my client had never had any formal status, even though he had been fostered by the same family his entire life. He'd never had any formal status with his family. He'd been under preventive supervision for his entire life. So he was effectively abandoned and placed into care where he suffered physical and sexual abuse his whole childhood. I argued that there should be a fiduciary duty, and it had been breached because it was clear that the reason why he never had any formal status was because the state was trying to save itself money, which is a clear fiduciary breach context. But the Court of Appeal held that I hadn't been able to establish a sufficient evidential base for that, even though I thought it was pretty clear in the records. And so we were able to succeed in tort and in vicarious liability, but the fiduciary cause of action failed. And I think the only times that fiduciary causes of action have succeeded in New Zealand have been where the abuser has been either a relation or a close family friend. Otherwise, I think we could probably say in New Zealand they will not succeed.
Thank you very much.
Thank you, Ms McCartney. Ms Dodds? Thank you. Ms McKechnie? Thank you. Ms Dyer-Kidd?
Good afternoon, Ms Hill, Ms Cooper. I act for the General Synod Te Hi Nota Whanui of the Anglican Church in Aotearoa, New Zealand and Polynesia. And so just to explain further, the General Synod is the governing body of the Anglican Church, which is made up of three houses: the House of Bishops, the House of Clergy and the House of Laity. Firstly, on behalf of them, I wish to sincerely thank you both for your tenacity and hard work on behalf of your clients, the survivors. I just want to touch on a couple of points at a high level. The first may well be an example. Later in this week, we're going to have the statement read of your client, Ms. Wardle Jackson. And in part, she deals with her contact with the Anglican Church, the abuse she suffered, and then the subsequent contact, which I have a letter here from you, Ms. Cooper, dated in 2004. Would you agree that your first contact was by letter to the Bishop in Wellington? Does that sound the usual approach?
Yes, and that I've had to remind myself, obviously I did that partly when I was helping Beverly with her brief, but yeah, so you can imagine it's 15 years ago.
Yes.
So yes, that would be the usual way we usually approach, and we still do that now where we don't know who to contact. We would usually approach who we think might be the head of the church.
And in that letter to the Bishop, you recorded at the end, and I'll read to you what you said there. You asked that the church seeks legal advice, and concluded, I look forward to hearing from your legal representative within the next 2 to 3 weeks. That's what your letter says.
Yes, and in those days, again, we were quite cautious that people got some legal advice to kind of help them understand what the legal liabilities might be, and also to assist them, hopefully to give them some guidance about how to embark on a process to engage. And we would still do that now too. I think we would, I think people should get legal advice, defendants or claimants. I think it's just because this is a legal context within which we work.
So you'd agree that you were expecting a response from lawyers?
Yep.
Now, my second question just relates to some terminology in the brief that you've just given, Ms. Cooper. And for instance, at para 262, where you refer to claims brought against the Anglican Church, and you say several parts of the Anglican Church rely on the Limitation Act. So I just want to flesh that out. When you're talking about, or when you talk about there about the Anglican Church, I understand you're actually talking about not just the parishes and the churches in the Anglican Church, but also other entities that may be seen in the public as affiliating with the Anglican Church.
Yes, that's correct.
And you'd agree that some of those entities are actually independent, legally independent.
Well, that was something I have to say. I've not been brought up Anglican, so I didn't know that. I think at that stage we were used to the Catholic process, the path to healing, so we were used to there being a homogenous process within a church, and we were also used to the Salvation Army. So we were used to dealing with a church entity that, even though it had its disparate parts, because even within the Catholic Church there are numerous different orders that have different processes, we were used to there being a homogenous process that we could attach to say this is how we might expect a claim to be dealt with. And so we were hoping that the Anglican Church might have something like that. So I think it was a bit of a surprise to us that the Anglican Church, given that it's the biggest church in New Zealand, had no process, that it was lots of different individual bodies that all did very different things. And I have to say that was incredibly frustrating for us because just knowing how an individual church body was going to deal with a claim, some taking a highly legal approach, others engaging in a more pastoral process, others just not engaging at all, was deeply frustrating and quite unsatisfactory. So as I say, we were hoping there might be some higher level process like the Path to Healing or like the Salvation Army had in place that guided all the different parts of the Anglican Church on how to deal with claims.
And again, when you say parts of the Anglican Church, you'll appreciate some of these technically are not parts of the Anglican Church. And so as part of our learning process, you actually reached out to the General Secretary of the Anglican Church by letter December 2016.
That's right.
Expressing your concerns at the approach that you'd encountered.
Yep.
And while the Church pointed out, or the General Secretary pointed out, the entity you were concerned about was independent, there then was an expression of a desire to meet with you.
Yes.
And there was a meeting which was held in May 2017 between yourself, the Archbishop of the Anglican Church, and the General Secretary, where you discussed your concerns with the process. They explained some of these issues around the structure of the church.
That's correct, and that was the first time that I'd really understood that the Anglican Church had these three different legal entities, and then I think in New Zealand that's divided into another 6 or 7 entities, so there are something like 18 different legal entities in New Zealand, and that was the first time that I'd really had a clear understanding of that. That, as you say, that was driven by our issues with the with a particular trust in Auckland, that we just felt we were being stonewalled. The other reason why we asked for that meeting was because we were aware that in Australia, the Anglican Church in Australia had got together and had come up with a protocol for dealing with claims in Australia, and we were very much saying to the hierarchy in the Anglican Church, when are you going to do it? It's clear that it needs to be done. So we were very strongly advocating at that stage that the Anglican Church as a body and including its various different legal entities get together, do what the Australians had done and come up with a protocol to deal with claims. And I have to say, I'm not sure that that's happened yet. I think we are certainly seeing some shift in some of the entities that we have dealt with that we would put under the Anglican Church umbrella. But even as of last week, or the week before, we had one of the bishops of one of the Anglican churches in the South Island basically brushing us off and telling us that we had the wrong defendant, even though it was an archdeacon who had sexually abused one of our clients. So I think we are still seeing with the Anglican Church, and again, I use that in umbrella, quite disparate approaches between the different legal entities. One thing I want to say, from my perspective, I mean, I've been raised Catholic, so I understand about church care. I think our firm is very much of the view that the churches owe a pastoral obligation to those who were abused in church care. They are a moral and pastoral obligation to put right abuse that has been caused in whatever context. And I think, churches and the state should not be relying on their legal defences and their legal technical ways of, removing themselves from liability to say no to claimants. Churches, as I say, have pastoral obligations, and they continue, particularly when often church abuse is so alienating for clients, not only in terms of where they feel in themselves, but also where they fit within their own families. It can alienate them from their families. So I think that's one of the things we say very strongly to all the church entities that we deal with, is you've got higher than legal obligations. You've got moral and pastoral obligations to remedy any harm that you've caused, or those, who've gone before you have caused.
And this is my final point to ask you about: would you accept that at that meeting there was a genuine willingness expressed to listen to you and to respond to those concerns?
Absolutely. We both, I was with another lawyer of the firm, Rebecca Hay, we both experienced that as a very positive meeting. But I think, as I say, one of the things we learned for the first time was just this very difficult legal structure that exists within the Anglican Church. And it was made very clear to us that it was probably going to take some years for the Anglican Church to kind of come together with a cohesive church protocol and policy that governs all parts of the church. And I'm not, as I said to you, I'm not sure where that work is yet. It's not evident yet, given what we've had even within the last couple of weeks. It's not evident yet that there is a protocol that governs the entire Anglican Church. And I think that's a real challenge to the Anglican Church, given it is the biggest church in New Zealand.
And no doubt, just on that point, it would have been explained to you that part of that is because of the way that there's decision-making in the Anglican Church requiring agreement across the board, and probably also requiring changes to canon law.
Yes, I understand that. I guess my response would be, we had that meeting at the end of 2016 and we're now at the end of 2019. So
it's not for me to give evidence, but Ms Hill was on the track when she said that things are in process.
That's right. And so, and I think that's one of the great things about having a Royal Commission, is that there will be a lot of challenges, I think, to people to do better, get protocols in place, and we're certainly seeing that even with our engagement with the Crown as well. So, that's all positive stuff.
Thank you both.
Thank you, Ms Dyer-Kidd. I'll now ask my colleagues if they have any questions of Ms Cooper and Ms Hill themselves. I propose to leave aside any questions until the redress hearing occurs next March. Judge Shaw.
Yes. Thank you both for your evidence, which was extensive and very interesting, and I believe, without any insult to you at all, preliminary. I think we have a long journey to travel in this matter, and for that reason, as expressed by our chair, I too will not ask any questions for the moment.
Thank you.
Thank you.
Dr. Erueti.
Kia kōrua. Ki te mihi kia kōrua. I too would like to thank you for your evidence. I just have one just quick question I was curious about. When you talked about how you use the UN treaty bodies to bring claims to under the Human Rights Covenants and also UN CAT, about whether you had also considered using the UN mechanisms that are there for Indigenous peoples, like the UN Special Rapporteur on Indigenous Rights, given the large numbers of Māori clients that you have.
Yes, we have. And so, I mean, we've basically every covenant that there is. So it's the same for disability as well. So essentially, every time New Zealand's been examined, and every time we've had an ability to make a shadow report, we've used it.
Can I just add a point? If I could just add to that, I do feel that there are people with perhaps that are better placed to make those complaints, and people like Ms Sykes and others who are engaged with the Waitangi Tribunal that have better knowledge about that kaupapa, and we certainly support that work, even if we're not doing it ourselves. We think it's a really important conversation to be having.
Kia ora.
Thank you. Ms Alofi-Vai.
Look, can I just thank you both also for your tireless commitment and the pursuit of justice for your client base. It really is admirable. I have two questions, but actually they are better suited for the redress hearing. So it's around the structural barriers that you have raised incredibly well and just requires a bit of unpacking, and just the personal journey that your firm had and the definite turning points that made it a lot harder. So just flagging that that's coming in March. Thank you.
Thank you. Mr Gibson.
No further questions at this stage, and thanks for your evidence.
Thank you. I want to also thank both of you for the prodigious work you've done in support of so many people whose plights have deserved it. Thank you.